Good morning, members, officers and members of the public if they are online, although I don't believe we have anyone. Welcome to this meeting of the Licensing Committee. My name is Councillor Annika Osborne and I will be chairing this meeting. Those in the chamber are reminded that the meeting is being live streamed. As there's no members of the public present, we don't have to worry about permissions with that. And may I ask, if you are joining us remotely, that you ensure your camera and microphone remain off unless you are addressing the committee. And for those of us in the room, ensure your microphone is close to you and you speak clearly. Hopefully you can hear me now. Okay, so if we turn to the agenda, the first item is apologies for absence. Erin, if I can ask you.
Thank you very much, Chair. And we've received apologies for absence from Councillors Sally Ann Hart, Corin Garvey and Lisa Redrup, but we are quorate.
Thank you. And online we have Felicity, sorry, I don't have my glasses to see your surname. Goldsborough. If you could introduce yourself, please.
Good morning, Chair. Good morning, Councillor Bradnam and all councillors. My name's Felicity Goldsborough. I'm a barrister. I'm the legal officer here today.
Thank you very much. And we also have Tilly, Councillor Warren Green online as well, who's the independent member.
Good morning. I'm just observing today. I was due to come in, but I haven't been able to, and I'm going to be online observing for my first time at this licensing committee. Thank you.
Thank you. So then item 2 is declarations of interests. As a councillor, you're reminded of the requirements under the Code of Conduct to register interest and disclose interest in a meeting. So does anyone have any interest to declare in relation to the items on the agenda today? No one's registered anything. If anything becomes apparent at any point during the meeting when we're discussing items, please just let us know. Then we have the minutes as item 3. Has everyone had a chance to look at them? They have been circulated. And are there any amendments? Councillor Bradnam.
Thank you, Chair. I'd just like to point out, because I'm sure you'll be too modest to do it yourself, is that in the apologies for absence at item 1, your surname has been spelt incorrectly. It would be nice to have that corrected, but otherwise they're fine.
Thank you. And no other amendments required? Okay, I move to approve these minutes as a true and accurate record of the meeting that took place on the 19th of October 2023. If I could have a seconder?
Yes.
Thank you, Councillor Bradnam.
Councillor Howell wanted to raise... Oh, second, yeah. Sorry.
Thank you.
Yeah.
And so everyone's happy for those to be approved, yeah? And I'll sign. By affirmation.
Thank you.
We've got item 4, which is public questions. There are no members of the public here and we have had no questions received. So we'll move on from that one. And under item agenda 5 is the review of the statement of the licensing policy under the Gambling Act of 2005. Just on that. So we have been given the revisions because the Gambling Act policy is only valid under the Gambling Act for a period of 3 years. It was published in 31st of January 2022, so it's due for renewal 31st of January 2025. So the committee is asked to recommend to the council that the revision of the new policy is agreed so that they can adopt it. Through the policy there are actually no amendments. So yes, Councillor Wilson.
I'm just looking at paragraph 5, which refers to the current policy is effective until January 2022. I suspect that's a typo.
Yes, that is a typo that was amended on the online version of the papers, but there is still evident in some of the published papers, so thank you for pointing that out. The sentence should read that it was effective until 31st of January 2025 and effective from 31st of January 2022, just for clarification. So does anyone have any comments they wish to make on this policy? So I would ask, Rachel, would you like to present on this matter?
Thank you, Chair. To be honest, I think
Chair, you've actually said everything I wish to say, and thank you, Councillor Wilson, for spotting the typo there. I was going to mention in the introduction, but as you quite rightly say, Chair, this is we have a statutory duty to publish the revised Gambling Act policy, which will have to take effect from January 2025. Thank you.
Yes, Councillor Bradnam.
Thank you, and thank you for the report, officers. One of the things I just wanted to observe was that at paragraph 15, obviously the consultation went out to the 104 villages plus all the statutory stakeholders, and we only received 2 comments from parish councils. And that suggests to me that, broadly speaking, that reflects, A, the fact that we're quite a rural constituency and don't have many actual gambling premises, although, of course, we do have slot machines in pubs and that sort of thing. But broadly speaking, it suggests that parish councils have not had any problems reported to them about gambling issues in their parishes, which suggests that the system is working well and it's being monitored properly. And thank you very much to the officers for that.
Thank you, Councillor. Yeah, I think that's a very fair summary. Thank you, Councillor Bradman.
Thank you. So the committee is now asked to agree the recommendation that we pass this to Cabinet for approval. Oh, one moment. So the full recommendation is... No, that's street trading. One moment, sorry. Thank you. It's recommended that the Licensing Committee recommends the Council the adoption of the statement of the licensing policy under the Gambling Act 2005 for a period of up to 3 years from the 31st of January 2025. Draft policy has been attached. Okay, that's agreed by affirmation. Thank you very much. We can move to agenda item 6, which is the street trading policy revisions, and if I can ask Rachel to present the report on this.
Thank you, Chair. I was getting quite lazy then and thinking you could say it all for me. Thank you. This is a periodic review of our existing street trading policy, which has been effective since March 2022. On the 27th of March this year, a workshop was held for the Licensing Committee to discuss proposed revisions to the street trading policy. A schedule of revisions was agreed and the policy amendments were drafted. A copy of the schedule of revisions is attached as Appendix A on the agenda. In a nutshell, we've just looked at, I think there was concerns about clarifying and making a bit clearer what the different types of licence or consents were. So we've addressed that in the policy. With also, in order to support the trade, looking at a new but not overly radical proposal of a trial period. So the same process would apply as if somebody's applying for a full consent. We still have the same consultation with the parishes, etc. But this would allow them to test the water for 3 months. And the other option for you to consider today, Chair, has been the new ad hoc traders. So basically this is again to either allow the trader to meet business needs by just operating a couple of times a year in one location, or again to test the viability of the location before they go and apply for a full street trader consent. So members are therefore asked to agree to adopt the revised policy. If there are no questions, that does conclude my introduction. But just as a reminder, Chair, and for the members here today, the decision for the policy lies with your licensing committee. So you have the final say, of course, in the committee, the policy. Thank you.
Thank you, Rachel. So I propose just to quickly go through the amendments, just see if anyone has any comments on them. The first one is in relation to consent to premises at paragraph 4, which is on page...
So are we looking, sorry, Chair, just for clarity, are we going to be using the numbers on...
Just as a, by way of explanation, there are some copies that have been distributed where the page numbering and the paragraphing has been differently referenced. So that's what Councillor Bradnam's just clarifying. Can I just...
Are we going to be looking at the amendments as they appear in Appendix B of our agenda, which starts at page 35?
Yes.
Yes.
Yeah. So if you open up Appendix B, the actual policy itself, page 38 on the PDF agenda. Types of street trading consent, there were various amendments there giving examples at changing it to 6 types instead of 2 categories, and listing the 6 types. Does anyone have any comments they wish to make on that? Yep.
You need
You need the microphone for the tape.
Okay,
For the recording.
I have a question, like on the here it is written the static street concern, mobile street and different categories. And
Is that
Do you
page
also-
39?
yeah, no, do you also listing out, are you listing out any food business from the home or like the private food business from home?
Are you able to answer that, Rachel, please?
Yes, thank you, Chair. The answer is no, because food registration is very, very different from street trading. This is on the street, this is on the highway registration. The environmental health, their food safety registration is completely separate from this policy.
Yeah, so I would like to know the regulations for that as well, like the food business
Yes,
from the households.
but that's not street trading
Not
with
street at
respect.
all.
No, so it's separate policy with within environmental health, councillor.
Thank you.
Thank you, Councillor Bhattacharya. So there's no comments in relation to that amendment from the committee.
Just one thing I observed was that, if you remember, previously there were just the 2 categories, and now there are 6. And I just wanted to, if you could explain the reasons for the 6, because it might appear to be more complex, whereas I think actually it's simplifying it. So.
Thank you, Chair. Well, absolutely right. It was before we had standard consents, which were then split into different factors. None of these have actually changed. They all existed before. We've just tried to identify them more clearly within the policy. So we haven't created anything new from what was in the existing policy. We're just trying to highlight each individual type rather than we had standard consent before, which could be a standard mobile, standard this, etc. So this, I feel, although there's 6 rather than 2 or 3, it certainly does clarify. We've tested it with people who know nothing about licensing whatsoever, and they said, we understand it now. So that's, for me, is a good indicator. Thank you.
Thank you. Yes, Councillor Hales.
Yeah, thank you, Chair. Just like to thank officers for the updates and what have you. Page 41, section 8, grounds for representations, refusal and revocation. The little bit in red, and evidence must be provided on. I think that's a very welcome addition. We've obviously had conversations in the past about street traders, Ms Jackson, so this is, as I say, quite welcome. I think evidence is key, shall we say. I'm very grateful. Thank you.
Thank you. Councillor Bradnam.
Thank you. I just wanted to be sure on that same point that Councillor Hales has raised, that people understand the nature of evidence. In other words, of course it's important that people provide evidence, but that could, excuse me, Councillor Bhattacharya.
Could you, I will note that you wish to say something in a moment. If you could just let Councillor Bradnam make her point, please. Thank you.
So people might be put off from reporting because they don't know what the evidence they need to provide. So I just think it might be helpful if somewhere we referred to the fact that this could take the form of a diary record, or I did query this, didn't I? And you clarified that it could be a diary record, a log, or a photograph. Because the point was that if you think that a street trader is behaving improperly, it's actually quite confrontational to go and take a photograph of it. So in that case, you wouldn't want a member of the public to put themselves at risk by going and standing in front of a street trader and taking a photograph, because there might be all sorts of recriminations. Particularly as the resident is likely to be a resident in a village and would be known. So I think it might be helpful to clarify what forms the evidence might take. So this could be a written record or photographs if they were able to take it, or the kinds of evidence that people could submit, so that they know that, yes, they must provide evidence, but that it could take a number of forms. And I think the point was that if people took a photograph, it needs to be date stamped, which of course, if you're taking it on a mobile phone, it is, but I think it just needs some clarification somewhere of what forms of evidence might be acceptable. Would it be possible to either expand that wording, so a representation against an application must relate to, and I think that should say an evidence must be provided of, rather than on, one of the following criteria, and then maybe at the end, evidence could include a diary note, a noise log, or photographs. Would it be possible to add that in, do you think?
Of course, Councillor Bradman. What we'll do is obviously I'll revise something and then it can go to our chair for final approval. It's not an issue at all. But just for members to they're aware, this actually rested with a decision that the licensing subcommittee had to deal with, which suggested evidence relating to public nuisance, for example, littering, etc., and numbers of residents complaining about an issue to a parish council. And it was very difficult for the licensing committee to make a balanced decision because the evidence actually was not there. There was information that showed littering not actually relating to the business in question. So it was it was an emotive matter, and this is really to assist you, the members, when you're making a decision at the licensing committee to make sure you're making the correct decision and you do have evidence to support your decision. A bit like the Licensing Act, but not as strong and not as strict with that. But we certainly, Chair, can put some information in there for you to have to look at. But I say we'll keep it very, very short, but to the point there for you. Thank you.
I think Councillor Hales just wanted to come back on something here.
Thank you. It was just Councillor Bradham's point. I was going to reinforce that about the authenticity of the evidence itself, photographic or otherwise. It has to be, it's key, actually. And whilst I accept that members of the public might want to write in and they send their pictures and their statements and what have you, part of the consultation process is local authorities. And I would expect local authorities to be able to provide chapter and verse, frankly, in what we request, as well as authenticated evidence, and not succumb to public pressure just to say what's being said, which can, on occasion, be completely and utterly wrong, and as Councillor Bradham said, terribly emotive. Thanks.
Thank you, Councillor Hales. Councillor Wilson wanted to make a point.
This is going back in the papers, it's just for a point of clarification. Under that ad hoc trading consent, we have an ad hoc trading consent can include up to 4 occasions at between 1 and 5 locations. Does this mean that, does this equate to 20 events?
Potentially, yes, Chair.
Thank you for the clarification.
Sorry, can I just come back on the previous?
Yes, Councillor Bradnam.
Thank you. I just wanted to point out that the helpful clarifications are included at Appendix C to this paper on, forgive me, I'm not quite sure which page it is, around about page 51, I think, which says, this is a response from Rachel Jackson to a question, and it said, photographs or video footage are helpful. However, the authority would never wish an individual to put themselves at any risk. So evidence such as diary logs or statements would remain suitable. However, where a body or a person wishes to provide photos as evidence, these would need to be date and time stamped to be valid. So that gives us the framework of the wording that could go in at that point. Thank you. Sorry, just on that.
Thank you, Councillor Bradnam. Yes, sorry, something, Councillor.
I just wanted to ask, when we say photos, should we clarify that we don't take photos of children?
It would be evidence of whatever they were complaining about, I'm assuming. But I
It's
don't know
a
if
difficult one then.
Yeah, I don't know if Officer Jackson can clarify.
I think with respect, Chair, we've got to be quite pragmatic here as well, because we can't be saying, should be doing this, should be doing this, should be. We've got to have an understanding that whoever's taking the photo knows they should not be taking photos of identifiable children, for example, unless, of course, there's 25 children causing the public nuisance, and then obviously they'd be filtered out in any case, the images. But we could seek some advice on that. But from the evidence I've seen so far, evidence has really been relating to litter outside the premises, or outside the unit, for example, not young children being. It's.
If I may,
Yes, Councillor Ansraj.
where there is antisocial behaviour and spoken to police, etc., we really should find out where we stand on photos about children.
I would think when it comes to child protection, with respect, anything like that will be dealt with by the police in any case. It wouldn't really be a matter for your licensing committee, unless we're obviously looking at a revocation, but that would be obviously with support from the police. So it would be more of a, with respect, probably a cut and dry decision for your licensing committee. If we've got serious crime, disorder, public nuisance issues happening at a burger store, for example, then and the police are getting involved, then all likelihood the police would be dealing with the matter before it even came to your committee. But I don't really feel we need to be identifying that. Do not take photos of children, because you're not entitled to do so. I don't feel it's appropriate for your policy, Chair, is what I'm trying to say. It's out of the confines of your policy.
Thank you. Councillor Bradnam.
But it depends what's the concern. So, for example, suppose an ice cream van located himself or herself in such a place that the queue of children ended up going over the road. You might want to take a photograph from the rear of that queue showing 12 children queuing up for an ice cream van and straying out onto the road. And you might want to say this is not a sensible place for an ice cream van to be located. That would seem to me to be a legitimate reason for taking a queue of a picture. But I don't know, would that be allowable? I mean, the point is, the only reason that should be inappropriate, and I quite take your point, Councillor Hansraj, but this would be sent directly to the licensing authority. It's not being sent, the question would be, and then you need to delete this from your phone. But the licensing authority can be trusted, and are all DBS checked and appropriately checked, to use that data appropriately. But it might be worthwhile checking it.
Yes, Councillor Ansraj.
I agree that it should be sent to us directly. However, I have known people to send it to each other because they haven't got the courage to send it forward to the police or such like. So I think that we need clarity on this. I agree about what you're saying about the ice cream one. Personally, I would send it straight away and delete it. But I know somebody who's been filming children causing a nuisance. I think it's something we need to look into. That's my view.
I was just wondering, Officer Jackson, if we could just clarify if there would be an issue with this. Obviously, if it's not being reported to us, that we cannot legislate for somebody just sending and sharing photographs. But it might just be worth checking with the legal department as to whether there's an issue.
Of course.
I don't know if you have any comments at all.
Thank you, Chair. I have just been researching it. I can't see it would be relevant at all. If you give me a little bit longer, I'll come back to you to see if there's anything to prevent that happening, you sharing the photographs. But I do agree with Ms Jackson that really it would be a matter for the police rather than the licensing committee. But I'll clarify that, Chair.
Lovely. Thank you very much. Okay, if I can then go back to Councillor Bhattacharya, if you have any issues, if we're finished with this one. What was the issue that you wished to discuss and go back over?
Yes, thank you. So, it is again the page number 36 or 38. Yeah. Does the food selling,
With page number?
okay, take the question like this. Does the food selling from the household business is allowed under our trading policy, in any of our trading policy? Because I see the advertisement on the Facebooks and everywhere where the food is being sold, and that food is exposed to the member of public. So do we have any policy for that? This is just a precautionary measurement so that our residents are good. I mean, from both the sides, from the seller point of view, from the buyer point of view. So there are the businesses are going on. The business is set up within the house premise, like the household business, and they are exposed to the member of public. Those advertisements are quite frequent on different community websites. So the food selling is going on. I'm just asking, what is our trade policy on that, so that both sides, sellers and buyers, are in a safer zone? In the page number 39 also.
Yeah, sorry, I forgot about this. Wednesdays, 10:30, it does always happen.
Mine's page 38.
Apologies.
Apologies to everyone, that's just the alarm being tested.
Yeah.
I've been advised.
You're 39.
So, can I just
So that is my
clarify?
question. But here also I would like to understand the consented premise and non-consented premise a bit of, is in a bit of little more clarity. And because you mentioned here and the other areas attached to the public houses, etc.
So, just so I can just be clear what you're asking, sorry, Councillor Bhattacharya. So, you're referring to people who are cooking in their own homes and selling it to people,
Yeah.
but via advertising, however they may do, Facebook or so on. And this policy is about street trading, but you're wondering whether it comes under the consented premises section.
Even not, because, I'm more eager to know the first one. What is our policy? Making food at home and selling it to the public and residents. Do they need to have any policy that is registered with us, or is it like that? Is it a very free business that they can do? Are they allowed to do this kind of free business? Because it is a food, it matters the food poisoning, allergies, and a lot of things.
Yeah.
I just want to know if we have any kind of trading policy.
That's fine, I'll refer to Officer Jackson.
Thank you, Chair. In short, Councillor, obviously any food business has to be registered. We've got very, very strict guidelines. Obviously, we've got our head of the food safety team here, but you don't need to worry about that side of it for this policy. This is completely standalone. What you must remember, anyone who is operating as a food business, whether they're preparing all the food in the trailer or the food at home and then transporting it to the trailer, must have met our food safety regulations. So that's a given. So if they don't meet our standards, they don't get the consent, quite frankly. So there's that part of it. But the food registration, the food business registration, food safety is a separate team from licensing, all within
Okay.
John's
Okay.
division.
Okay.
But they have to meet the very strict guidelines before they can go ahead and, if it's more than just an ad hoc kind of provision. But yes.
Sorry, is the crucial point that if I quite take your point, Councillor Bhattacharya, there are probably lots of people working from home and producing food and then selling it. And people might be actually going to their door to pick it up. Yeah. Or they might be delivering it using many of the local delivery networks. So the question is, for these companies that are working from home, that comes under, if they are selling, they have to be registered. And if they are selling and not registered, is that illegal?
Yeah, they would not be meeting the food standards regulations, yes. So that would be a matter for environmental health to deal with. It's certainly not a matter for this policy. There was another question, Chair, I think, regarding consented premises and non-consented. I'm not really quite sure what the question was. Or was it about relating to... Right, so, yes. So the answer is, for that part of it, Is a private home a consented premises? The answer is no, because you have not got free access to number 27 Green Street. You can't just knock on the door at any time and just walk through their house or walk into the garden. You would be trespassing. So that is out of scope for what we call a consented premises. This is, to give you an idea, this is open space, typically a pub car park, where a member of the public can walk through any time without any restriction. So that is what consented premises is private areas which are open to the public. A private residential address is therefore not suitable for a consented premises because it is not open to the public. You haven't got free access to that person's home. Thank you.
Thank you very much, Mr. Jackson. So if I can refer back to the amendments in the policy, the next amendment is at point 9 on page 42, which is the amendment in relation to the receipt of an application from the traders, just to update it, I believe. Councillor Bradnam.
Thank you. I wanted to understand why under 9 we've got the list of types of consent. So on receipt of an application for static street consent, mobile street consent, lay-by trader, consented premises or ad hoc, that's 5 of the 6 categories. They must apply, they must consult, the local authority will consult and seek observations from this list of people. But consented premise, if they receive an application for a consented premises trader, only the Cambridge Constabulary, only the police will be consulted. And I just wanted to ask, why is there that distinction between who should be consulted? Because if if a trader is applying, why wouldn't you consult all these other people?
Thank you, Chair. Just to confirm, I think Councillor Bradman, Chair, just to confirm, this hasn't changed since 2022. This has always been the case with the consultation. The fact of the matter is, it's the location which we're looking at here, and this is to provide a passported system. So we as officers have checked and see that this person is registered for food safety. He's got all his insurances, for example. So why does it matter if at the White Swan, on a Tuesday, we have consented premises number 1, which is selling fish and chips, and then on a Thursday, we have Mo selling his kebabs, for example. It's of no relevance at all. What we're looking at is the impact for the amenity, is the fact that the actual premises is entitled to host these vendors. So there has been, to say to you, right, I'm going to consult now because Pimp My Fish, he wants to trade all 15 locations here on a Monday, the first Monday of the month or whatever. Practically that would be impossible because he can't be in 15 places at the same time. But then we'd have to consult with all the parishes, everybody again for that. There is no logic to this. This is a simple process to allow for a passporting system. The premises is the one who's responsible. So if the premises is hosting the fish and chip van, which is causing lots of unruly behaviour, then that's how we would address it. We would then have that person not being able to trade there, or they would lose their consented premises status. It's not practical to then say, if someone like with a personal licence to go and check, he may be a relief manager and he's going to 17 different pubs. We wouldn't then consult on those 17 different pubs because we've got a relief manager in place. We're talking about a different piece of legislation, but that is the principle of it. This has been working very, very well for 2.5 years with how we've got it existing. So there would be no, it would time-wise, cost-wise, resource-wise, there'd actually be 0 point in this because the idea is it's meant to be a fast-track process to allow a trader to pop up at one of our, I think, Tasha, we've got 12, 15 consented premises around that kind of number now at any of these locations to give them the flexibility.
So,
Councillor Bhattacharya, could you just turn your microphone off, please? Thank you. Councillor Bradman.
thank you, Ms Jackson. So one of the things I just wanted to check was, suppose one was you were a local parish council, and your neighbouring parish council had problems with a particular trader who routinely allowed a lot of litter to be scattered about after their their trading, and they then applied to ply trade in your local parish. So how would that, but you wouldn't know about it because you wouldn't be told. They'd just turn up in your village on the consented premises, and one hopes they wouldn't, but they might scatter litter all over that premises.
But the parish council will be consulted on the actual application for consented premises.
Well,
You'd still have to be consulted
but
on
the premises
that. Yes.
might already be consented. Might be other, they might have a perfectly good relationship with a number of other traders in that consented premise, and they have no problem with them. But Joe Bloggs's wonderful burgers might turn up, who've been causing problems in the next door village and cause the same problems in this premise. I'm just wondering how that is dealt with.
Would that be dealt with on the basis of the licence for the trader rather than the licence from the consenting premises? And that's why you would then have the consultations.
Thank you,
for that
Jane.
basis.
There's actually two options for that. If there was an issue with the trader, their consented premises trader permission would be suspended or revoked. And also, we could do the same as well with the premises. So the premises would not be allowed to host anybody at all if littering, for example, seemed to be a cause of the issue.
But the point is that when you're asking for a consented premises, which, as you say, is a location, and I quite understand that, these bodies would be consulted.
Yes.
But the parish would hear about it if Joe's Wonderful Burgers turned up on the consented premises and then caused a whole load of problems with litter. Is it when it turns up and causes a whole load of problems with litter? They wouldn't have been consulted before.
If I can share, yes, thank you. It's quite like anything, isn't it? It's a bit like saying you've given this permission for this mobile unit to be here. The parish are quite happy because, somebody's waffle factory is rocking apart in the village.
They've given permission for a location.
Yes, but what is the whole thing is each trader is applying the same set of rules, the same restrictions, and the same conditions. So it should not matter if everyone is being a responsible trader, then that should not be an issue. If they are causing an issue, a bit like a pub, if the pub starts causing an issue, we expect the parish to contact us, to contact the noise team. So this is what we do as a regulatory body, Councillor Bradnam. So for me, we have to allow that flexibility. Otherwise, this scheme, quite frankly, would not work. We may as well just say everybody then has to apply for their own consented standard permission at the White Swan. So we've got 17 people all applying for consent for the White Swan. Yes.
Sorry,
Yeah.
if I may clarify.
Of course.
Thank you, Chair. So the point being that if Joe's Wonderful Burgers is causing a problem elsewhere, then it should be dealt with wherever it was before it came to your parish. Do you see what I mean? That would be dealt with by complaint and report, and then Joe's Wonderful Burgers would be asked to tidy up their act.
Well, that's exactly what the Chair just clarified as well, is if we have an issue with Joe, do we deal with Joe himself? Is the answer yes, we can. We can revoke Joe before he moves on to cause havoc elsewhere. Thank you.
Thank you for the clarification. Councillor Hales?
I'd just like to say I haven't done anything wrong. Okay, keep referring to me as Joe. I mean, I haven't done anything wrong.
Are there any other comments on the amendments at paragraph 9 for the trade? We'll move on to paragraph 10. The amendments are, again, just clarifying the traders, and then H has been added. There's just a typo with agency at H. If anyone's got any comments regarding H, I, J, K and L. No, everyone's happy with that, lovely. And if we then turn it over page to page 44, we have the addition of the consented premises trader. If anyone's got any comments regarding that. No, everyone's happy. Sorry, Councillor Bradnam.
No, that's fine.
Okay, lovely. And then, so consented premises trader, there's no comments. And then we have the paragraph 11, removal of grandfather rights. Does anyone have any comments regarding this? No. Okay, that's lovely. And then, subject to renumbering, the next one is at 15 was 16 on page 45, the renewal of continuation of consent. Just to change must to should, and then the removal of a sentence. In that one, does anyone have any comments in relation to that? Councillor Howes?
I've got no queries with this at all. I think this is great. I think I just want to reaffirm my comments earlier, Chair, which is there's been a lot of work going to this, and I suspect that there's been some recent cases that may have triggered this review, and I am very grateful to officers for what they've done. There's a lot of work gone into this, a lot of thought, and like everything, there will be the odd hiccup along the line, that some bright spark, called Joe perhaps, who can work his way around a different rule set, and that's fine. And then we'll come back and we'll tweak it afterwards. But I think as the starting point, this is way down the line of good, or brilliant, if you like. I'm chuffed a bit. So thank you very much to officers.
Thank you, Councillor Howes. That okay with comments? And Councillor Howell?
Yeah, sorry, are we on page 44 now? Or?
We have, yes. And then we've got page 47 is the last. Is it page 45? We were talking about what was point 16.
Can I ask a question on page 44, please?
Of course you can,
yeah. Just a quick one for Rachel. I see there the applicants under C, the applicants must be 17 years of age or above. Is that standard? I know for some reason I've got 18 in my head, but it's just a general question.
Yes, just
Thank you, Councillor Howell. And so we'll revert back. Then the last amendment is at what was 20, now 19, conditions and enforcement, with the addition of the final sentence. Sorry, Councillor Paddon.
Sorry, can I just go back? On the renewal continuation of consent, can I ask why we have relaxed the requirement? So it used to say an applicant for renewal must be submitted no later than 4 weeks prior to the expiry date of the current consent, and we've relaxed that to should be submitted. Is there any particular reason for that? Thank you. Yes, thank you, Chair. Quite simply, it was an administration issues we were having. We have a new software system, which should be allowing us to send renewal reminders to traders, because traders originally, who've been with us a while before the existing or current policy, would have a license that could have been issued in November, ended in November. So we were having renewals dotted all over the place. So we did find, unfortunately, that some people were thinking, oh, I don't have to renew my licence because it doesn't renew until November, when in fact we all have a common expiry of March. So we're working to try and have a renewal system in place for this, but also it's to give us a bit of flexibility, because somebody could apply for their renewal and they put it in 4 weeks exactly to the day before the expiry of their old consent, but they've forgotten to include, say, their insurance, because their insurance was the wrong insurance, which then means, unfortunately, sorry, we can't accept it because you're now 3 weeks and 4 business days, for example. So it's just to allow that flexibility. There's nothing in law that says a renewal period must be this and this, and sometimes people just call it continuation. But for me, it was just a pragmatic approach to deal with it in an administrative way, quite frankly. Yeah, that's fine.
Thank you. So that was back to 19, conditions and enforcement. Are there any comments regarding the amendment and the addition of the paragraph at the end? No, everyone's happy with that. In which case, that is the end of the amendments to the street trading. Yes, Councillor Sharia? Sorry, could you turn your microphone on?
I just need a clarification. No amendment, nothing so complex in it. On the page number, like the page 37, out of scope. Page 37, out of scope condition, when it says the following activities are excluded from this policy, where there is a point which is called trading at a fair, fete or a similar one-day community event. Do we have any listed items for this community events, or what they can do and what they cannot do? Because in two examples, I was requested to bring some medicinal herbs. I didn't know it is allowed or not. And in another case, someone actually came with a blood pressure, blood sugar measured equipment just to sell to the public, and I was also not sure it is allowed or not. So when we say that trading at a fair, fete or a similar one-day community event, do we have a list what we can do and what we cannot do?
Okay, just to clarify, that's page 38 under paragraph 3B. It's the fourth bullet point down. Officer Jackson, do you have any clarification for that?
Thank you, Chair. The simple answer is in 1982, when the Act was created or agreed by the powers that be in government, that was the exemptions they were provided with. So my simple answer is, if you know of anybody who's planning an event, just ask them to send me an email or send the licensing team an email and we'll confirm what is required. But as say, a one-off event, you know, having vendors there, like a community fair, for example, would be absolutely, I'm looking at Councillor Bradman here, so I'll say Water Beach Community Fair. It doesn't exist, but it might do next year now, she's got the idea. That, for example, you know, one-day event, with vendors and traders popping up there, people selling goods, selling the jams, and also selling perhaps other equipment, they made handbags, for example, would be out of scope for the one day. So just think of it as literally a one-off event would be exempt. And I don't want to confuse you, but also we have the markets, which are a separate regime, which is out of scope for here as well. But the golden rule is, if there's any question, any doubt, please just either send our chair an email, I'm sure Councillor Rutland would like to be saying that, or myself, and we can obviously get you the answer for that.
Okay, thank you very much. And Councillor Howes?
That was a really good question, actually, Chair, because it's now triggered off the old grey juices. Thank you. Melbourne Hub, right, close to my heart, as you know. We're working very closely with the NHS, and there has been some chit-chat that we might hold some weekend events where a number of medically clinicians, if you like, and what have you, and agencies thereof might come to the hub and either demonstrate or sell their wares. So under that premise, they would still need to be cleared, I suppose, for that, regardless of the fact it's the NHS. So I think perhaps it's the premises which are more needed to be looked at rather than necessarily what's going on, but I don't know if that's correct.
Officer Jackson?
Yeah, thank you. Are we assuming the hub is behind closed doors, so to speak? Or is a hub an actual outdoor location?
It's a building.
It's a building. So a building, that's what, yes, behind, when I say behind closed doors, that sounds very suspicious. But I mean, behind closed doors, in other words, it's not on the highway. So you can, quite frankly, do what you wish within
it's
reason.
Off the road, it has its own grounds and what have you, so any event would be contained within that.
Yeah, that's absolutely fine, Councillor Hales, because it is not part of being on the highway. That's the key thing here. So if we have a pop-up trader event here, it's not in the public highway. So it's in closed doors, it's in a building, it's in a premises, so it falls out of scope, basically, it's a short answer. So you're okay to continue.
Okay. Does anyone have any other further questions in relation to this policy? That's all right. No, that's fine. All good? Okay, so if we can go, our options are to recommend that the policy is published, or recommend that the policy is published with the amendments we've just discussed. And then there is also, in addition, we are to recommend to agree that any minor revisions to the policy be delegated to the Head of Climate, Environment and Waste in consultation with the Chair of the Licensing Committee. If I can take the first choice first, I would propose that we recommend the policy be published with the amendments.
Agreed.
Agreed? That's agreed by affirmation. And then could the committee also agree whether they agree with the recommendation that any minor revisions to the policy be delegated to the Head of Climate, Environment and Waste in consultation with the Chair of Licensing?
Agreed.
Agreed? Again, agreed by affirmation. Thank you very much.
Sorry, Chair, before we move on.
Yep.
Thank you, Chair. Just to cover off the discussion earlier around photos and children. So there's just a message from our legal advisor here, just with some advice. So I'm just going to read that out for the benefit of the committee. So it is legal to take photographs in public. The consent of parents and children are not required. There are arguments under the European Right Act and European Convention on Human Rights, read the right to privacy. But considering the lack of specific legislation and balancing the right to privacy, the advice of our legal advisor is that if it is considered reasonable, proportionate and necessary to take photographs or film, you can do so. However, it does not need to form part of the policy.
Thank you very much.
Thank you.
Thank you.
So,
Councillor Bradnam?
so that answers Councillor Hansrage's concern that there is a right to take photographs of children. It's what you do with them afterwards that matters, and if it's just simply sending a photograph to the licensing office, then that seems fine, which is reassuring.
Thank you very much, Councillor Bradnam, for that.
Thank you, Aaron.
Okay, if we could go to the next policy, which is Agenda 7, the Hackney Carriage and Private Hire Licensing Policy. Just to point out that, apologies if it takes me a while, again, I've got the old version of the papers and I'm going to be trying to refer to the new version, so just have patience with me if possible. If I can ask Rachel Jackson to present this report.
Thank you, Chair. In November 2023, the Department of Transport Best Practice Guidance for Taxis and Private Hire was published. Licensing authorities must give due regard to the statutory standards when setting their taxi and private hire vehicle licensing policies and procedures. Where an authority does not apply the standards, it needs to provide strong defensible reasons for doing so. In April 2024, the Licensing Committee held a workshop to discuss and agree in principle the revisions to the policy as per the new guidance, and considered some local aspects and agreed to remove the driver handbook, which officers considered had become obsolete over the years, and produce a more succinct policy. The summary of the workshop agreements, together with responses to the consultation, is attached as Appendix A. I won't mention page numbers today for obvious reasons. Members are asked to consider the feedback received from the consultation and agree what additions or revisions should be made to the proposals numbered 4, 5, 9, 13 and 14, together with revisions to the penalty point scheme, which were agreed at the workshop. Finally, members are also requested to agree a revision to the safeguarding training requirements, so as to require training to be undertaken in a classroom environment, which may be either remote or in person, and where the attendees can actually be verified and in person. And the course must include disability awareness. There are also some other minor admin revisions, mainly for clarity, which have been highlighted in the draft policy, but I'm aware that you didn't receive a highlighted copy version, thanks to Councillor Osborne confirming this morning. So the copy I handed out has got the highlighted revisions in there. They're basically minor admin revisions, nothing that has an impact on the policy overall, but just for clarity, they've been highlighted in yellow in your handouts this morning. If there are no questions, that does conclude my introduction. Thank you, Chair.
Thank you very much. So again, I propose to go through as the policy reads. So taking the copy that was handed out to us today, the first one that's highlighted is at page 79 under paragraph 7B2, and that's actually in relation to the classroom environment safeguarding changes, just the inclusion of the course requirement. Councillor Wilson.
Is there another copy of the handout? Because I didn't get one. Oh, I'll share. We'll share.
You're right. Okay. Thank you. Does anyone have any comments in relation to that amendment there? Yes, Councillor Waters.
Sorry, I don't seem to have one.
It's the amendments are in the agenda pack, but they're
printed
on
copies.
they're on the page numbers that Annika has given, that the chair has given. So they will have been in your agenda pack as you read it, Councillor Waters.
Do you have can you see where we're referring to, Councillor Waters? It's on page 79 in the new pack.
It's 79 in both
It's
packs.
paragraph 7B2, if you're looking through the paragraph numbers. Councillor Hales, you just want to mention something?
Thank you, Chair. Yeah, it's also on Modern Gov, so for colleagues can access Modern Gov, all the highlights are on there as well.
Thank you. just want to confirm that she's accessing it. Councillor Sanford.
Thank you, Chair. 7B2 goes on to say there is no limit for the number of attempts to complete the test, which seems to conflict with one of the proposed changes on page 59.
For the three requirement.
Maximum 3.
Yeah. If you can clarify.
Yes, Chair, we can delete that part. Thank you.
Can I just check, Councillor Waters, are you happy, you know, where we're referring to?
Appendix B of the
Vision.
Yeah, apologies. There were some issues with the printing of the original document, so the page numbers were off on the ones that you would have received it. So it is page 79, but the page numbers have gone a little wonky. So
It's the
just
page before 82 on the misprinted version. No, page 82, you are right. Yes, page 82 it says at the bottom, and page 79 slightly above. Is that the copy you have? Yeah. Yeah, so it's paragraph 2. It says, halfway through, the course must be undertaken in a classroom environment, remote or in person, where the attendee can be verified in person and must include disability awareness. And then the sentence after this will be deleted, that there is no limit for the number of attempts to complete the test to be borne in the applicant's own expense. At the applicant's own expense.
Because elsewhere in the policy, it limits the number of times that the applicant can take the test.
That's a new amendment to
That's another
limit it to
amendment
3.
which we'll come to.
Is everyone happy that they're able to identify what we're referring to?
Agreed.
Yep. Okay, so does anyone have any comments on that requirement being changed and the sentence being removed at that point? Sorry?
Yes, it's good.
It's good. Yeah, it's a better change, yeah. Thank you. So on the same page, possibly, is at C, at 2, which...
Adds the wording operators.
Yeah, that's on the same, it is on the same page on the printed copy that you'd have. It's adding a sentence, operators are also required to ensure all dispatch staff has been subject to a basic DBS check, but the checks do not need to be provided to the authority. Yep, Councillor Howell.
Thank you, Chair. Chair, with regards to this particular one, my question is quite simple. How would we know, if they have to be approved by the authority, how do we actually know that these have actually been done?
Thank you, Chair, and thank you, Councillor Howells. It's a very good question, but as I say, it is a basic requirement of the operator. It's something we should have actually had in the existing policy. We didn't have it in. It was an oversight, unfortunately, as part of the previous best practice guidance. So it's a basic recommendation. A bit say, for example, how do we know they are employing people who've got the right to remain and work in the United Kingdom? As an employer, this is their responsibility. So this would be part of, in the policy, we'll obviously be reminded of that requirement to have people DBS checked. I just do not feel it's a matter for us to determine the suitability of an operator who they are employing, if that makes sense. I think that goes beyond our role as a regulatory body. Because it's not a requirement for the licensing authority in the guidance to actually have sight of the DBSs, if that makes sense.
Yep,
I wondered if Ms Jackson could just clarify. As I recall, we've got the drivers who do have to be DBS checked, and they sign up to the subscription, and that gets checked. I think the operators have to apply with that too. So this is relating to dispatch staff, that they are engaging to do the dispatch. Now, bear in mind, we know some of these dispatch staff might not be in Cambridgeshire, they might be anywhere, depending on where they're having to access a dispatch system. So, as long as it is said that, so my concern is that the drivers are DBS checked, and we can check that, and the operators are. That's our responsibility, and that does come back to us, and we do have sight of that if we have an appeal hearing. So from your point of view, your argument, and I support it, that it's for them to determine that their dispatch staff are DBS checked. Would they also be required to sign up to the regular
There's not a requirement for that, but financially it's probably cheaper for people to subscribe. But that'll be an employer as their decision, quite frankly, what they decide to choose.
Thank you. Are there any other comments in relation to that, Councillor Bhattacharya?
Yeah, first of all, classroom teaching is good, as I said, but many times the drivers or the applicants, they say that they didn't understand the language. Most of the drivers are not, English language is not their first language. So can we make it sure that, can we please create a provision to ask them finally that if they understood all the application, the application form and the policy, can we make some provision for that?
Officer Jackson?
Thank you, Chair. Yes, well, the answer is, if you go back a couple of minutes ago, we talked about the classroom environment for safeguarding. Safeguarding is such a critical role for taxi drivers. They have a massive role to play in our community. This only came up a couple of weeks ago when I was at a meeting with one of our potential new safeguarding providers who said, it's okay to have an e-learning course. You go in there, you do your multiple choice questions, and you probably don't absorb 90% of what you've read. Whereas this course provider was actually saying, we have real life situations about safeguarding. If the applicant, i.e. the driver-to-be, is at the course, the online course, and you're thinking he or she isn't really engaging here, then what they do is actually have a one-to-one session with them afterwards to make sure their command of the English language is suitable, that they actually understood what was being said to them in the real life situations. If that isn't happening, they will then contact us and say, actually, Mr. X is not really, we don't feel he's suitable because he wasn't getting any of the course. So that's point number one. It will be in our new process. But currently, all our drivers are subject to a validation check, which is a one-to-one on Teams with our officer. So we receive his application. My officer then will have a discussion with the driver. We'll start off with some general questions, just day-to-day questions, before they go on and say, do you understand about this, this, and this? So we've also got a competency test, which they have to do, which obviously will check their knowledge of the local area and, of course, the conditions, etc. So they're questioned on that already. So once they've done all that, they then have a chat with our officer. And if the officer thinks, actually, when you say, we actually had one yesterday, funny, I've had a chat with her, she said, oh, she was asking the gentleman just very things about, why have you come here from Peterborough? Why are you applying from Peterborough? The driver looked very blankly at her, and he looked up, and you could see he was lip reading because his wife was behind the screen saying, translating basically. So she's going to have a follow-on meeting with this applicant. And we have got, in law, we're required to make sure they have a basic command of English language. So if this driver fails that test, then they will be required then to undertake a basic English language course to get that quality. So you're absolutely right. It is all about the safeguarding and making sure they understand, which is before, when we had a 140-page handbook and a pretty similar sized policy, it's an awful lot to absorb and read in there. So this is why we're trying to, as a licensing authority, try and make it simpler, keeping all the valid, important aspects in here, but making it more manageable for everybody.
I have a follow-up question. Is this any way, can we make also the translation course? Is it helpful like generally the NHS has many translation courses, like the actual policy material, even if they understand the basic language, they can speak the basic English language, but do not understand the 180 page, the thick policy pages after pages. Is it possible to give them a translated version of the policy?
Thank you, Chair. Thank you. I feel like a councillor. I'm sat up here with you, so I feel too important up here, I tell you. Well, the short answer is anything is possible. You could provide translation, but the guidance is, and the expectation is, you are conveying members of the public. So your command of the English language, written and oral, should be at a level that you can meet those requirements. Because if you're in a vehicle and somebody says, I'm not feeling very well, I was meant to go to the Sainsbury's, but I need to go to the doctor's, I need to go to the hospital, and you don't have a translation of that, I'm sorry, you just have to, there's a general expectation. The potential, you could say, as a chair, as your committee, you could actually say, actually, we'd like all the conditions translated, but currently, the volume of, I mean, I did this previously, but it was a long, long time ago, and there was about 6 different key languages that were spoken. Now I think when we're doing a review, I think there's about 145 different languages. So if we're providing a language in 2 or 3 key languages, whichever foreign languages are most key, we're going to be then perhaps saying we are being prejudicial then about we're discriminating against one particular community because we're not providing it in X language. So I think we're going to get into, it's quite a difficult position. We obviously have Google Translate, for example, which does a reasonable job, but the expectation is for safeguarding as a licensing authority perspective, we should be expecting a command of English language which is appropriate for the job involved.
I would agree with that. Councillor Bhattacharya, did you have a
Yeah, I have to say something on this because English is not my first language, even it's my third or fourth language. So the communication with English with a friend or customer is very easy. Like we can chat constantly for hours, but sometimes to understand the policy in a very lawful language, that might be a different case than the communication with the customer. So I'm just asking to help them, the drivers, because so far I attended in all the panels, all of them they came from outside and they are not English speaker. So just trying to help them with a policy which is written in their own language. Most of the cases I found they are coming from Middle East or Pakistan or Bangladesh. If it's 3-4 main languages, if you can see statistically which is more required. So reading the policy line by line, by heart, understanding them in their own languages is much easier than understand English in that case. But they are very much eligible to talk to the public in a common English language.
Councillor Hans Rush.
So I don't know how helpful this comment is, but when we started recruiting nurses, we saw a shortfall, something that was lacking. Yeah, they came in with their training, just like taxi drivers have passed their tests, etc. So we had to, for applications, we had to have the ESOL.
English speaking is
yeah, and we're not just, we can't have, you quite rightly pointed out, if there is an emergency, you have to dial 999, speak to the operator, this kind of thing. You can't do it with, you can't work in a public service without having a basic communication skill in English.
I just want to point it out, please. I want to point it out. They have fantastic basic English communication skill. They do not fail there.
Councillor Bhattacharya, I do feel you've made your point. It's about the technical terms in the policy and being able to understand that as opposed to being able to convey in a conversational matter, I believe.
But the communication is fine.
Yeah.
It's just sometimes the policy making there they need to understand deeply in their own
I can
languages
understand,
from the Eastern European language, and a lot of people are coming from there.
Yes.
So they are very good in communication, the basic communication.
Yeah, I do understand your point. Councillor Hales, you had a point.
Thank you, Chair. Councillor Howell might back me up on this a bit, but this has been discussed in council iterations in its 4-year cycle for a number of cycles, I would think, at least 2, possibly 3 back, where people of other languages would struggle to read, if you like, the legal English that is used in policy itself. And it was discussed a while back, if I recall, about whether or not we could have a handbook with the various languages that we enjoy within the taxi trade as a starter. I just wonder, a question to Ms Jackson, I just wonder how many nationalities that we license, if that is recorded for a start, right? I mean, do we keep that kind of data on obviously those varying languages? And whilst I agree with all the speakers, there's good and bad in both things. The policy has a draconian aspect to it. If you misbehave as a driver, you'll lose your license. Like, right, if you do something wrong, you'll lose your license. Operator, blah, blah, blah. So you do need to be able to understand exactly what it is you're going to do wrong, or potentially do wrong and not do it, right, which is the idea. So I just wonder, A, as I said, how many various languages do we enjoy within the trade in our scope, and what would be potentially the likely cost to develop a handbook? And it would not be, in my eyes, something that would do away with being able to speak and communicate with the English language as is where you're working, but it would be a way of making sure that that individual understood chapter and verse what was required of them, and then their basic language skills could then be put to be used elsewhere. But it's the absolutely, do you understand what we're requiring of you question.
That would be,
Just before you go back,
sorry, can I just
point out
1 minute, can I just say something, sorry. So the question then is not necessarily conversational, it's the policy itself, that when they are signed up for the licensing, that they actually understand the policies that they are being required to comply with. And as Councillor Howe said, how many languages are there, and what would be the implications of translating those into other languages?
Yeah, thank you, Chair. We don't actually have a record of ethnicity on an applicant. Well, people apply for it, but putting it this way, we've got around 1,900 drivers, I think, if we're looking at that kind of level, or nearly 2,000. So obviously, people are either applying for a job in this this function where we are expecting the whole safeguarding. They are conveying people. They've got probably one of the most important jobs ever, conveying vulnerable people who are on their own. The requirement for the basic English language is obviously necessity, as we've covered here. I'm only referring to 140 odd languages because we're making different processes. I'm not going to bore you with a lot of detail, but with the personal license application, that's been changed to an online form, and there's a suggestion that we have nationalities in there, and there's 145 different nationalities on a drop-down menu, which would be quite a difficult thing to achieve. For the cost involved, if you wanted to explore this, we can do it separately from this committee, Chair, to be honest with you, but we could maybe look at identifying, say, the top 10 different languages, and then looking at the conditions being translated, perhaps. I think to do any more would perhaps, I don't want to say good use of public funds because I need to get advice on that, but the effort, time to have this document translated, and then I think, as Councillor Hales has mentioned quite rightly, we've had about 4 different reviews in the last 3 years of this. The additional cost then of having it translated again and making sure that it's up to date and making sure that the quality remains and certain words are translated correctly, so it still means exactly the same, is quite a big ask for a local authority. You maybe wish to consider, or maybe ask me to have a look at seeing the cost for translation for the conditions, but it still remains, there is an expectation that, if you think about it in the Transport for London, even people who were English born and bred were expected to be passing and providing evidence of their English language training. So another option could be, we'll look at formal training, English language, get a GCSE, for example, in English language before you can apply for a taxi driver licence.
Okay, there's been a few hands, one minute. So I've got Councillor Bradnam, Councillor Howe and Councillor Hansrod. Councillor Bradnam.
Yeah, my point was simply when Councillor Hales mentioned the handbook, the whole point is that this policy, now we no longer have a handbook, it's all embedded in the policy. That's all I was going to say.
Thank you. And Councillor Howe?
Thank you, Chairman. If you don't mind, I'd like to ask a question to, and then so from that question, then my statement. Can I ask, please, how many times have we been asked for a policy to be given not in English? How many requests we've had so far?
Since I've been here, none.
Okay, thank you. May I make a suggestion that should we be asked for something in a language other than English, that the licensing officer, in conjunction with the chairman and other appropriate people, then make the decision whether the expenses be paid?
Yes. Is everyone happy with that? As a suggestion? Okay, if you're happy, I think that's one to consider. Thank you. I think that's a good way to deal with it. Councillor Hansrod.
I just need to ask, once you've given someone a handbook, is there any kind of
policy?
Oh, beg your pardon. Is there any kind of test that they have to do to show that they understood? I mean, Not e-learning, I'm not talking about e-learning, just a test.
Yes, there's a number of, sorry Chair, thank you. There are a number of courses and certificates they have to go through. So the safeguarding one was a very good one, example about English language. Currently the competency test or knowledge test, that is currently note, e-learning. And that will say questions on there, multiple choice questions about the local area. What road is X golf club on, for example? What do you have to do after you've had an accident, etc., etc. What we have done as well is we know the policy before was very long, and sometimes it wasn't that logical. So as you see, what we've got in our new policy is responsibilities. So I'm applying for a taxi driver badge. What do I have to do? What are my responsibilities now? Are very, very clear because they follow on. I've had an accident, what do I need to do? Which is something was mentioned, I think, by Councillor Bradman at the workshop. Make it a bit clearer. How do we know where these responsibilities lie? So these now fall quite nicely within the policy because it's a lot easier rather than thinking, page 22 mentions taxi drivers, then page 147 says I've had an accident, what do I need to do? I've had a change in my medical circumstances, it's on page 17, for example. There was a lot of toing and froing, so this is to make it a lot clearer to read and understand for people who English is their first, second, third and 23rd language, quite frankly. It is meant to be a lot clearer for all readers, to be honest, on all licence holders. So there is, the range of conduct, the range of tests, in-person checks as well. So a lot of processes you have to go through before we actually hand over the golden licence. So yes.
Lovely. Councillor Bradman.
Thank you. I also wanted to reassure Councillor Hansraj that before any applicant can take the application for to be a licensed private hire driver in South Cambs, they have to show evidence that they have passed the competence test, the safeguarding test, the English language test, the various different tests. So they have to have evidence that they've passed all those before they can, otherwise they won't be eligible to apply for the private hire driver's test.
Of course, yeah.
From what you both say, I don't see a need for translation. I really don't. This is something that we have experienced in the NHS, so I'm just saying.
Sorry, thank
Councillor
you. I hear what Councillor Bhattacharya says, but my feeling is if somebody is applying for a job of this type for this authority, their command of the English language should be sufficient that they understand the policy, which actually is written in very simple language. It's not legal language. It's very straightforward, and it has been made more straightforward by this revision. And it's important that they can communicate with the people in their vehicle, which we know many of them can do. But that is their responsibility. That is not our responsibility. It is their responsibility to undertake that language training such that they are of a sufficient competence that they can undertake the test.
And I would also agree with Councillor Howell's point that if we have the requests for it to be in another language at that point, I think then we can address it moving forward. I think that is a practical way of dealing with this issue, if everyone agrees. Okay. If we can move on from that point then.
This is important because you are not considering I'm saying you may do, you may not do it. You may be kind, you may not be kind. Like we, I'm not using the word you, I'm saying we may not be the kind. Those who are coming for as a first generation, who didn't born here, they came here for asylum, they came here for different reason. Because in my 6 years of experience in licensing, at the most the three, four languages I found, and they also have a very, very huge community, driver community here. I know them. They are the language they are speaking Urdu, the language they speak Bengali, language they speak Polish. I know these Urdu speaking drivers. I know the Bengali speaking drivers.
We do understand the point you're making, Councillor Bhattacharya.
That thing the council is not getting the point. They are thinking that passing GCSE is enough for them. No, it is not.
We're not saying that. What we're saying, Councillor Bhattacharya, would you please let me speak?
The knowledge of English, basic English is different.
We understand.
The knowledge of understanding the lawful English is two different things.
Councillor Bhattacharya, could you please let me speak? We do understand that there are different levels of language. There is the communication and there is the policy. As I referred to you earlier, I said that there are the two, and as the other members have acknowledged. At the moment, though, as Councillor Howell asked the question, nobody has asked for this to be in another language. As Councillor Bradnam has mentioned, it is the responsibility of the driver, if they don't understand these policies, to be able to come and say to us, I don't understand this, can I have some clarification? At that point, we can do it. I also understand the points from both sides, but as a practical purpose, I believe the way to move forward, and most of the members have agreed, is that if the request comes in, at that point we start looking at whether there is a top 10 number of languages, what the costs implication is to the council, and I think that's a practical way to take it forward. And that is what we aim to do when an issue arises. At the moment, nobody has asked for it to be in another language, so I think at the moment this is where we are. If we can move forward onto the next amendment. I've just got a question of Officer Jackson. I have in the responses to proposed amendments Appendix A, it says at point 15, there's a proposed change to the decision under the Local Government Miscellaneous Provisions 1976. I cannot identify where this is. Is it in the new pack, page 82, paragraph 12? It's not highlighted, so I'm just clarifying.
Apologies, Chair, it's not, because we've made reference to appeal throughout the current policy and the new policy, but range of powers referred to it at 12 in the draft page. I've said 82. Forgive me. That should be in 82 in your.
So it's 82 in the new.
Yeah, 82, for example, so in your new today's bundle, should we say?
Which is
page 82, number 12.
Page 81.
Right, where it says right of appeal. Yes.
Yes.
So it's in there and elsewhere dotted about as part of a right of appeal. So, yeah.
So it's paragraph item 12. So is the proposed change to amend
Yes, I asked that actually.
the whole paragraph to this new paragraph?
Yes, it will be to confirm where we mentioned the right of appeal. We will make sure it says where a driver is aggrieved, an applicant for a driver licence is agreed by decision. We remove the reference to the Licensing Appeals Committee and it will go to the Magistrates Court. So as you say, it's as per the kind of Appendix A is where we'll make the changes.
Yes, Councillor Bradnam? Yeah. Oh yeah, no, I was just to clarify for the paperwork. So it's page 82, paragraph 12, under right to appeal. Sentence A will be amended to the proposed change in the change document, which is Annex A. If everyone just knows where that is, just to clarify. And then Councillor Bradnam.
So this embodies, so if an applicant's, the proposal is that it should say, where an applicant is aggrieved by the licensing authority's decision to refuse to grant, renew, suspend, revoke a licence, or by conditions attached to a licence, the applicant has a right of appeal to the Magistrates Court within 21 days of receipt of the decision. What this is taking out is, I think, the opportunity to have a panel hearing in between, isn't it?
Yes.
Could you just talk us through the reasoning behind that? I know we talked about it at the workshop.
Yeah, quite.
Thank you. Could you just remind us?
Thank you, Chair. It's a legislation, quite frankly, because we are saying we have, as officers, we make a decision based on your policy that you've agreed. That is the authority's decision. Basically, we are then saying to the driver, we are rejecting your application because you've had armed robbery, for example, 4 years ago. You go against our policy. So that is why we are not bringing that decision then to the licensing subcommittee, puts you in a very, very difficult position as councillors, because you are then asked to, first of all, overturn an officer decision, which has been based on your policy, with your convictions and previous convictions policy. Ultimately, you are then deciding as a committee to go against your own policy. So it's actually to protect you as councillors and your licensing committee, but it's basically within the legislation. It doesn't say you get 2 bites of the cherry. It says we as officers have made that decision to refuse based on your policy, your convictions policy. So basically that is it. So your right of appeal is sent to the Magistrates' Court. It should not be to your committee, your subcommittee, because it puts you in a very difficult position, quite frankly, because you're having to then say, I've recommended to adoption of council this policy, well, you know, to our cabinet rather, this policy, but then you're actually making a decision against your own policy. It makes no sense. It puts us in a very compromising position. Also then puts into question the validity and strength of our own policy if you as members are then deviating from that policy.
Thank you.
Thank you.
Thank you. That's great. Yeah. Councillor Bradnam.
Thank you, and I think it's worth saying that, reminding us that's why it's changed, because what the effect of this will be to have quite a considerable fewer number of panel hearings, won't it? Because that was the main reason for having panel hearings. And I think this is a good idea because it takes out that jeopardy of the panel being required to deal with an appeal from somebody who's appealing against what's been decided on grounds of policy, and it's asking us to make a different decision, which not only puts us at odds with our officers, but also with our policy. So I think this is a good move, and it should reduce the amount of hearings that we have to hear. Are there circumstances that will still justify coming to appeal panels?
Thank you, Councillor Bradnam. Thank you, Chair. Yes, in short, there will be. We've had some. We have something called the NR3S, which is a National Revocation Refusals, easy to say sometimes, register. And so we'll also contact a previous licensing authority. If the driver says, I've been working at Peterborough, Peter may come back and share some information that says, we revoked him for X, Y, and Z reasons. So it's there. So it's not black and white, i.e. he's not had a conviction necessarily, or he could have had some convictions which are kind of beyond the policy, but it's put into question his suitability to be a licence holder. So those would come to you still. So you're not completely away from us, unfortunately, or fortunately for yourselves. But I say, thank you, Councillor Sanford, for your nodding there. I like that. Thank you. But in all seriousness, you still have questions. Where we are at it's a grey area, perhaps. Difficult to give you a couple of examples, but Tasha, we've had quite some recently where not tick the policy trigger, but it's just we don't feel that he is fit and proper. And of course, you will still be getting anyone, the current drivers as well, possible revocations and suspensions as well. So you'll certainly have those as well, but just not as many where it's an obvious trigger of the policy, which gives you a very difficult job, quite frankly.
Thank you. Can I just ask a point of clarification? In the pack, paragraph 12, there is a sentence in brackets, unless refusal to grant a Hackney carriage proprietor's licence where the appeal is directed to the Crown Court. That isn't noted in the amendments. Does that remain?
It does, yes.
It does. Thank you. Does anyone have any comments on this amendment? No? Okay, then we'll move on to the next amendment, which is as part on page 84 at 14C. In other cases where such information received as part of an application process, such as intelligence received from another authority which may be put into question the driver's suitability, and the application is refused, the applicant will have the right to appeal to the licensing panel or the Magistrates' Court, such as clarifying what was said a moment ago, I believe.
Well, no, this actually does give, where there's a relevant conviction, and the application is refused, the applicant will have the right of appeal to the licensing appeal panel or the Magistrates' Court.
So in that case, you've got either or.
Is that as an alternative? Is that one of those exceptions that you were talking about?
Thank you. No, this is really saying that the highlighted part. So we're saying already the applicant's the right to lodge an appeal. First of all, we've said before, where relevant conviction, that's the Magistrates' Court. If there's other information received, as I say, from X person's been suspended by X council, then we would refuse it. If we're not happy, as officers, we'd refuse the application and then give them the choice, because it's not directly linked to our policy, as a previous convictions policy. Just the information we received, we don't like him, we don't think he's fit and proper, so we'd give him the opportunity then to appeal to the panel. That was a decision.
Thank you for clarifying that. Does anyone have any comments about that? Okay, that's fine. Move on to the following page. So it's under G of the same section, page 85, sorry. Yeah, so under the same section, under G, renewal of application requirements, it's the second bullet point we have added, found in previous convictions policy. So further information can be found in the previous conviction policy. That's a clarification point. Does anyone have any questions? Comments? No? Okay. And the next one is at page 89. It's subparagraph M of the same main paragraph, and now it includes the option to inform the authority via an online report form. Does anyone have any comments with that one?
Seems sensible.
Okay. At 2, there is the addition and provide photographs of the damage caused when a driver is involved in an accident. Does anyone have any comments in relation to that? Councillor Hales and could you put your microphone on?
Would it be worth having timestamp? You know, we're going down that road with everything else, so you can't mess with the evidence.
Officer Jackson, is that something that could be added?
Absolutely, thank you, Chair.
And Councillor Howell?
I think there should be an onus on us on how quickly we have to inspect the damaged vehicle, because it could be somebody's livelihood there. So we should have, if once it's been reported and we assess that it needs an actual physical in-person inspection, we should be under a particular time limit where we have to inspect, and I think that should be 3 days.
That's under subparagraph 3 in that one, yeah. Officer Jackson, do you have any comments in relation to that?
We can, it's a fair point, and I think if you let me have some thought over this, I can get a proposal for the chair with our final document, so we can certainly put something in here. Clearly it depends on the severity. If it's just a slight dent to the wing, for example, I might just say get it repaired. If it's serious damage, the vehicle will be suspended right away in any case and told to go to the MOT testing station, because obviously we're not mechanics at the end of the day. But yeah, it's a valid thing to include in there. We will X hours, whatever. Yep.
And Councillor Wilson?
Thank you. Should we require the vehicle to have a further MOT before it's back into service as a private hire vehicle?
Officer Jackson?
Thank you, Councillor Wilson. It depends really on the nature of it. If someone has just said, oh, a cyclist scratched the bodywork, for example, then we know that could be repaired. There's not been any damage or any question to that. If the vehicle has been rear-ended, for example, then of course we'd suspend the vehicle licence until it's had its MOT and certificate of compliance. Definitely. It would depend on the nature of that, which may well be determined when we have the vehicle in for inspection. If someone says it's in a compound, it's in pieces, then of course the licence has gone in any case. But if it appears to be minor, you know, a scratch on the bodywork, but obviously if there's any dent, which could say supports the axle damage or anything like that, then we'd have it MOT'd again.
Councillor Wilson, did you want to comment?
I'm only asking this because my husband recently had an accident where somebody refused priority and damaged just a wing mirror. That was the only damage, and he had to have an MOT done on that car before it could be insured again.
I think, to be honest, a pragmatic approach, a wing mirror damage would be nonsensical to expect the driver to be off the road and spend £90 on a new MOT and certificate of compliance for something so minor. But anything that puts into question the actual safety of the passenger and of course the driver, we would then have to take a sensible approach and assess each one as we visit, as we see.
Councillor Bradnam?
I think on the point that was made earlier, we just need, at paragraph 3, it clarifies that the damage to the vehicle will be assessed by an officer, and if an in-person inspection is deemed appropriate, the vehicle may not be used for hire or reward until the vehicle's been inspected. So that encompasses the fact that it may be quite minor or it might be quite major, and it also encompasses the fact that if it's serious, it needs to be inspected. But the question in my mind, so yes, I think there should be a time frame on that, as Councillor Howell suggested, but they can only do that by driving the vehicle here. So if the vehicle is seriously damaged, we would not want them to drive the vehicle here. It ought to be taken to a garage to be mended. So I just think there needs to be some wording in there that puts the onus on us that if it's minor damage, that it's inspected, we undertake to inspect it in a relatively swift time frame that's manageable by officers. But if it's serious, then clearly it needs to go to a garage to be mended. Can we leave the officer to consider wording that
Is there any
encompasses-
guidance in relation, sort of following on from Councillor Badnam's, is there any guidance in relation to what you would deem as a serious crash?
Unfortunately not, Chair, no, and that's the thing, that's why keeping it within here, if an inspection is deemed appropriate, and if an in-person inspection is deemed appropriate, so if it's completely, you know, you can't drive the vehicle, then of course it's off the road, the vehicle licence is suspended, so we can do a suspension without seeing the vehicle. That's why we ask for the photographs, so we can make the judgment call. If it appears to say a small minor damage to a little dent in the door or the wing, then it is drivable, it's still safe. We'd expect the driver as a professional to say, actually, I can't drive the vehicle to show you because the airbags have all gone off, for example. Then we know obviously that vehicle is not fit. So we'll say, if you are looking at, you know, insurance claim, etc., if they are going down the other route, it would be, as Councillor Wilson's asked, it would be a full MOT and certificate of compliance if the damage is that sustained, is that concerned.
My point was the other side of that argument, which was if it was deemed that an in-person inspection is appropriate, then we'd undertake to do it within a certain time frame. And I was suggesting that we leave that wording for you to draw up and check with the chair.
Absolutely, that's right, that just follows on from Councillor Howell's, his comment about the time. Yes, thank you.
And Councillor Sanford.
Thank you, Chair. As far as I'm aware, MOTs only apply to vehicles over 3 years old, and they're probably not a suitable test for verifying that accident damage has been correctly repaired. We really are relying on the officer's inspection for vehicles less than 3 years old, or possibly the insurance company's assessor. So please don't write MOT into any policy.
There is the amendment in relation to MOT requirements as well, that's part of the policy moving forward from start as well. But I understand
that'll
your
be
point
fine
about
for older vehicles, but
Officer Jackson, do you have any comments in relation to that?
Yeah, thank you, Chair. You're quite right. Under the Department for Transport guidance, the requirement is an MOT is required regardless of the age of the vehicle now. So that's a slight change. But I think you're absolutely, just to confirm as well, Councillor, if we've had, you know, a vehicle that's sustained so much significant damage, and it has had, we've happened before, the vehicle's been off the road, you're thinking it's a complete write-off, we do then see the whole assessor, insurance assessor's checkbox of exactly what has been done, the whole cost of what's been done, and it's fit. So it's not just to say, not just an MOT, not just a certificate of compliance to say he's got his first aid kit, etc. in the vehicle, but also that full assessment, or the RAC as well, doing a check as well, the extensive check, and the AA do them. So we've got a lot of measures to use on top of our standard garage checks as well. Thank you.
And just that is clarified under the same paragraph in 4, that there may be time requirements and suspension notices may be issued.
Yes.
So that's all clarified in there.
Thank you.
Okay. Are there any other comments in relation to this? And is everyone happy for the officers to go back and look at the time scale and come back to me?
And bring back some wording about the time scale.
Yeah, and bring back appropriate wording and move forward from there with myself.
Good. Agreed.
Agreed? Yep. Okay, for the next amendment, I've got in the new pack, page 92, is the wheelchair private hire vehicles. That's a new one. That is under paragraph 16V.
Roman 5. Yeah, 16.
Yeah, V. Some of the numbering is, it's under GV, some of the lettering's slightly off there. At the beginning it goes AA, BD, but we're not referring to those matters. So it's under GV, the private hire vehicles that have been specifically built for wheelchair users, which can include after-sale installation after-sale installation of a tail lift or ramp, are only required to meet at least Euro 5 emission standards. So that's a reduction of the emissions requirements. Councillor Bradnam?
Thank you. Interestingly, I just happened to look at the licences issued by this authority to private hire drivers and their vehicles just the other day, and I noticed that there is about one or very few that actually have wheelchair accessible vehicles on our South Cambs fleet in my village, sorry, to be clarified, in my village. And so one of the things we need to be aware of is that we need to provide wheelchair accessible vehicles for the travelling public who use wheelchairs. And so it's really important that we have enough vehicles that can provide that service, and that when somebody who uses a wheelchair calls for a taxi, they don't have to wait for twice as long as everybody else to get a vehicle that's suitable for their needs. So this is a relaxation in the emission standards to allow that those vehicles that are currently wheelchair accessible vehicles, that we can meet the Euro 5 emission standards, because that gives, it's a reasonable standard for emissions, but it also enables those wheelchair accessible vehicles to continue, whereas otherwise I think the policy would have excluded them because it required them to have lower emissions. And I think although this is, it's not, we don't want vehicles with high emissions to go on ad infinitum, this gives a little more flexibility and it maintains our wheelchair accessible fleet. So I think it's a good revision.
Thank you. Does anyone else have any comments? Councillor Wilson?
I would support that view as well, because being a temporary wheelchair user, I've experience of this, and it is very difficult to hire a vehicle that will take a wheelchair.
Thank you. Any other comments? Okay, good. So we're happy with that one. And then further down the page at 17, the first bullet point, is this the amendment for the MOT tests to be required for all vehicles regardless of age? Does anyone have any comments in relation to this? No. Okay, we're happy with that one. Okay, so the next amendment is at page 94, so it's paragraph 20B, delivery signage and roof signs. So this is the amendment that were discussed at the members' workshop in relation to door signs and identification plates. Does anyone have any comments in relation to the new amendments? Councillor Bradman?
Thank you. I think it's worth pointing out that in the public consultation on this, there was quite a lot of request that there should no longer be a requirement for door signs. And at the workshop, we worked through that. My own personal feeling is that, and it was written in one of the representations, that actually it's not necessarily the customer in the vehicle who spots a problem. Sometimes the reports are made by people who are standing by the side of the road who observe something that they feel is behaviour or an incident that they feel needs to be reported, and that's much easier to do from a door sign or indeed the rear plate than it is from inside. So I'm very happy that we do have the door signs, we continue to have the door signs displayed.
Does anyone else have any further comments? No? I personally also agree with Councillor Bradnam. I think they're an easy identifier. It's as a safety issue, personally, I would feel more comfortable that they remained. I do understand the objections that have been raised, but also there has been an operator who's also, again, affirmed my belief from a safeguarding and safety issue that they are an additional point that does help with the identifier. Councillor Hales?
Just a question for Mate on the permanently affixed council issued door signs and what have you. It says not the magnet fixings and Velcro, yeah, which I understand. So do we have to spell it out? I mean, the most obvious is vinyl, isn't it? So vinyl sticks to the bodywork. So do we need to spell it out for people? Because otherwise, I've got a very strong magnet. It's not going to come off. You know, the argument is perhaps take away the argument and just say it's vinyl. You can't take it off. You can go for a car wash is notably identifiable as a private hire or cab, whatever it's doing, whether it's on duty or not.
Sorry. Just Councillor Hales, it does say in the first bullet, magnetic fixings, Velcro or similar are not permitted. So I think it's self-evident that that kind of application is necessary.
But is it just that instead of not permitting, we just say what we want? Is that the point you're making, Councillor Harris?
I'm very much of an identifier of people's belligerence. So state the obvious, he said, cleaning up the statement.
State what we want.
Make it absolutely undeniable. This will be a vinyl sign, end of.
Officer Jackson, do you have any comments?
Thank you, Chair. Yeah, with the vinyl sign, it's something we talked about a couple of, I think, when I first came to this authority, looking at other options for plates. And we said, oh, actually, rather than have a hard, rigid plate, which comes with a clear plastic back, which then must be screwed in, you take the number plate off, you screw it behind the number plate, and it's securely fixed on the vehicle. There are other options available, but this is all about procurement at the minute. So there are options that have there's basically 2 taxi plate providers in the country. One provides a stick-on that just peels off and you recycle that and it doesn't go into landfill. The other one's a hard plate which is getting recycled. So as it stands, Councillor Hales, you're quite right, there is a vinyl one we stick on, but currently it's still the rigid plate, and we provide the plate with the plate hole. This is the this refers to we're talking about the white identification plate on the rear of the vehicle, in such a manner that the plate does not obscure the vehicle registration plate. So this is the first part, which is still within the policy. So this is all about the plate, because we have had before the plates being very creative, bits of string, bits of coat hanger, magnets and all this kind of thing. So this is for the plates themselves. The door signs are provided, which are the adhesive. You're right, that's a vinyl. But we also had the problem with them was originally provided magnets because the magnetic door signs were working, but then it was just finding out so I'm not being very articulate here. So basically, the stickers are the council issued door signs, the adhesive door signs now. We did have the magnetic form. So we're talking about two. I do apologise. We're talking about plates and the signs, but yes.
Yeah, Councillor Hales, are you happy?
That was my. I apologise, Ms Jackson. I wasn't specific yet. I appreciated in the first bullet point was the plate at the back. Fine, job done. It was the second bullet point, which is the door. So, just to clarify, we provide the vinyl sticker.
Yes. Council issue.
End of. That's it. So that's fine. Thank you.
The only
I misread it.
Sorry, if I may, Chair, the only difference is for Council House as well. Operator signs, we don't specify because they provide them themselves, can be magnetic vinyl removal purely because the driver can only, if he works for 2 companies like Uber and Panther, can only display one door sign. So they can be magnetic. We ask for them on the door signs, but sometimes, because of the aluminium bodies of some vehicles, you might see them not on the doors, which might look odd, but on the tail end, because that's all they'll fit, that's all they'll stick to. But you're right, so our signs are prescribed. No issue with them. Thank you.
Thank you. Does anyone have any other comments in relation to the signage? So on this one, we have to make a member's decision, and we've got the options of maintaining the need to display identification plates on the rear of non-exempt licensed vehicles, or to require door operator signs to continue to be displayed, which would be against the Department of Transport standards, which say that the signage isn't necessary. So we would need to agree a rationale for requiring operator signage at this point. And considering the responses to not require operator signage, to consider responses to replace the need for identification plates with window discs, which was one of the comments that was made by one of the respondents or a group of the respondents, which personally for me I don't agree with. I don't know if anyone has any comments in relation to that. Councillor Bradnam.
Yeah, we looked at this at the workshop and we concluded that we did not support the use of window discs, despite the fact that one of the drivers or some of the drivers suggested that. The narrative is actually in the
highlighted section.
What is it, 1, 2, 3, fourth bullet point under private hire vehicles, the second paragraph, because it says The Department for Transport Best Practice Guidance suggests that operator door signage should not be mandated. However, in the interests of public safety and fact that many journeys commence or end outside the district and many on hours of darkness, having clear door signage is of paramount safety to passengers and drivers to ensure the correct vehicle accepts the booking. This was the conclusion that we came to at the workshop. So I'm very happy with that to be there as the narrative to cover it. But did you feel we had options?
No, so this was the options that were provided to us, and E was an alternative agreement. Based on the discussion that we've just had, for me, I propose that we maintain the need to display the identification plates on the rear of the licensed vehicles, and we require the operator door signs to be continued to be displayed, which, as Councillor Bradnam's just read out, is in the interests of safety for the passengers and the drivers. So that would be the option I would propose choosing if everyone has any comments.
We're all agreed. I think we're all agreed.
So agree by affirmation on that one?
Good.
Lovely. Thank you. So now we have page 95 under 20D, duty to notify the Council of Accidents. Again, that's the addition of the via an online report form, if anyone has any issues with that.
Seems very sensible.
And then again, the following sentence, paragraph is to provide photographs of the damage caused. Does anyone have any comments in relation
Sorry,
to that?
Chair, can I just propose that whatever we agree for the previous one,
Yep.
we just mirror here as well, because it
Okay.
falls within the responsibilities of a driver to notify of the accident, and also if you have to be a vehicle proprietor as well. So we'll just, whatever you agree rather, we will then put in place
Put into
here
place
as well.
there
Thank you.
Yep, no, that's fine, thank you.
Vehicle proprietor responsibilities.
Thank you, yeah. So, yep, so we've had the photographs, and then the damage will be assessed by officer. So again, that would mirror what we've decided previously.
It will mirror, sorry,
It will mirror the driver's responsibilities.
under section 15, which is the driver's responsibility. 15M so it'll mirror the wording in there here.
Which is where we discussed having the timestamp and the time obligation for the local authority. And then we have under E, vehicle inspections. At E3, under the Department for Transport Best Practice Guidance, the driver should undertake a walk-around check before the vehicle is used. So this would be in addition, a new additional check for them to do, where more than one driver is using the vehicle during the day's running. The driver in charge of the vehicle should make sure it's roadworthy, safe, carrying out their own walk-around check. Drivers are required to retain the vehicle checklist as proof. A mobile phone app may be used. We have had some comments that were given to us from operators. I don't know if anyone has any comments in relation to these. Councillor Harris?
Yeah, great. The mention of the app. So are there various apps that do this, or is it just one app? And if there are various apps, should we list the apps, or at least list them on the website? So these are the various apps that you can choose from that we understand do this job. You know, again, make it easy for people not to fail.
Officer Jackson, do you have any comments?
Yeah, thank you. We can try and certainly. I mean, I did a quick search on my phone. I found about 2 or 3 different checks as well. So I think giving examples is absolutely fine. It's interesting because I think a lot of our neighbouring authorities are being a bit scared about this one because it's excessive, quite frankly, this requirement. But I think obviously it's in the guidance. I think you'd be hard pressed to justify why you didn't, as members, wish to comply with it. But the original guidance was suggesting a paper check, and I think 365 pieces of paper every year was a bit excessive. But I think finding an app solution is sensible. But we can certainly find examples of what apps, mobile apps are available.
Councillor Bradnam?
I think there are only 2 or 3 apps doing this at the moment, but you can bet your bottom dollar there'll be more before long. I just wonder whether we want to want to be sure that if people are using an app to do this, that we're happy that the app is doing what's needed. I just, not now, but in future, do we want to consider coming back to this and reviewing it maybe in a year's time and see how it's working and whether drivers are using it, or maybe in a short period of time?
I think if the chair's happy with this, we're going to have to do any other policy review soon, in any case, with regard to emissions and the 2028. Also, there could be some other driver standards that are coming out nationally. So I think if we leave it until we're having a natural review of this policy, if it does come out that actually this is alarming, we haven't thought about X, Y, and Z, then of course I'll raise it with the chair, and it may be one of those minor revisions that we can just put into place without the need for a policy decision. But we can talk about that as and when.
Can I just suggest that we review it the next time we review the private hire policy?
Yes, what she's.
Yeah.
Yep, I'm happy with that, and I think that's what Officer Jackson's just kind of proposed, that it's included in the review. Councillor Hales, do you have a comment?
Thank you. The obvious question, as soon as it's a DFT best practice guidance, does the DFT have an app? If they have an app, then the only recommendation really is to use the app that because they require the guidance, or they've issued the guidance and the best practice, so it's their rules, not ours. So use that app, end the conversation, really.
Do you know if they have an app?
Unfortunately not. There's been a lot of proposals within this to say we should be doing X, Y, and Z, but nothing actually to firm up how it can be delivered. But as you say, it's early stages. As I say, although it was last year, so I'm not aware of other. I think Wolverhampton. I'm trying to remember whether they've actually put it in theirs or not, because they reviewed their policy, didn't they? I know you read the changes, but to be honest, yeah, I think just reviewing it as we do naturally, it's part of it. We review the whole policy. Everything else, something may come up, and actually we haven't thought about it, or a change may be required. As you have members of, got some local intelligence, we can just review on when we're renewing it.
I think it would also be interesting to see what apps are used when you get the checks in.
Yes. Yeah.
Chair,
Councillor
I'm confident, if I may before, Councillor, I'm confident that the DFT will step up to the plate and provide this information. As all government departments are very much on the ball. Thank you.
Thank you, Councillor Howell.
Thank you, Chairman. With regards to this, I agree with what Councillor Hale said earlier on, but also about getting it done, and there shouldn't be an excuse for not doing it. And therefore, I do think that we should put something in there that if we have to inspect the car, or any with regards to, somebody comes, how their car's had a bump, that we will be asking to look at their walk-around inspection. Just a small line or something like that is in there. That's all I'm asking for. Thank you, Chair.
Thank you, Councillor Howell. Councillor Bradnam.
Just to point out, if you go over the page on page 96, so it says for practicality, a mobile phone app may be used for this purpose. But then it gets quite draconian. It says if a driver is unable to provide the checklist to an authorised officer within 7 days of the request, the vehicle licence may be suspended until a new MOT test and certificate of compliance has been undertaken, which is quite strict. So the onus is on them to, this is not a requirement, it says a driver should undertake a walk around, but then it says, second line up from the bottom of page 95, drivers are required to retain the vehicle checklist as proof that they've undertaken a vehicle check. So the question is, are we noting that this is Department for Transport best practice guidance, which is basically guidance, it's not legislation, and are we saying we're hoping you're going to do this, or are we saying we note this but we're not requiring it yet, or it's a bit unclear as to whether we are saying we would like you to do this but we're not going to be draconian about it just yet, but we might get draconian about it when we do the next review of our policy, or are we saying you should be doing this, you should be keeping a record, every time you bring your car here, we will check that your record is up to date. I think we need to give a bit of clear guidance to the drivers as to what we're expecting them to do. And I'm not quite sure what that is, yeah? So.
Thank you. Well, ultimately, thank you, Chair. It is really, from what Councillor Adams said, it's your decision. This is what you're here to determine. Do you think it is excessive requirement? If so, where's the rationale to say, we hear it, but, But I think to put in a policy and a bit wishy-washy, because that's why I put on, you're quite right, to say, if you're able to provide the checklist, then we could actually we'll suspend your licence, because we're showing we do want you to do this. There's no point, we either mention the policy and enforce it, or we find a way of saying, actually, we note it, but we're not really going to do anything about it, which then waters down the whole policy. So there's no, for me, this is why I put it in there. It did sound quite severe, but it shows that there is an expectation that you should do this, but you must retain. That's a difficult thing, again, with the should and must and what have you, but that is the DFT guidance on there.
Well, my comment would be, it says the vehicle licence may be suspended, so I go, that allows for you to have a bit of leeway depending on the circumstances, I'm imagining. Yes. Councillor Hales? Or Councillor Wilson, were you first? Councillor Wilson.
Reading this, I have a couple of questions. Does the DFT set out what those checks should be? And are the checks set out anywhere? Because if I was a driver coming to this, then which particular aspects of this vehicle do I need to be looking at?
Thank you, Chair. Yes, Councillor Wilson, there is actually I haven't put the details in here, depending on what your committee decided today, but there is a template checklist, which, as Councillor Hales said, has been actually really helpful from the DFT. So there is a paper version of that checklist available to show exactly what is expected in the walk around. So if you wish to put this in the policy, we'll have reference to that. That'll be part of the appendices. The checklist will be part of the appendices, if that's what you want, Chair.
Can I just ask if people are happy for the template to be part of the, and referred to be part as an appendix and referred to from this paragraph?
I think for the sake of clarity, that would be helpful.
Yeah, I agree. Councillor Hales?
I just wonder, you know, like stating the obvious, which I think sometimes is best practice as well. So we've got the DFT best practice guidance mentioned there. So that's obviously a reference to a government department saying this is what we want you to do. And whilst it's not legislation, it is best practice. Perhaps we could say where a driver should undertake, we could perhaps the SCDC licensing department requires you to undertake a walk round. So therefore we become firm in our thing, and then as you go through the thing, we ask you to make a record of it, whichever app you wish to choose to do. And then as Councillor Bradman said, as you go over the page, if you're unable to provide those checklists, then essentially we can have you in 7 days and sort you out, basically. So it's basically what it's done. So there's a tiered response, but it is making it very clear in answer to Ms Jackson's point, is it can look a bit wishy-washy, as you said. Now we're not wishy-washy, we are very definite. We would like you to do this, please. We're being very polite about it, but it's in reference to their guidance. We're making it a requirement in our process. We value the safety of your passengers under our licensing scheme more than your sensibilities. Get on with it.
Officer Jackson, I think that would be a sensible proposal if that's possible.
Yes, thank you, Chair. I'm just thinking what might, if you are in agreement to this, rather than what I put E3 under the DFT guidance, maybe we revise that to say as per the guidance. That's a thumbs up from Councillor Hales, so I take it you're happy with that.
Yep.
I like a purr, Miss Jackson. I like a purr.
If it is everyone happy with that amendment?
Yeah.
Yep. Councillor Howell, can I just ask if you turn your microphone off for me? Thank you. Okay, so under this section, this does actually require a member's decision. So this does actually require a member's decision, so we need to take a formal decision as to require a walk-around check to be undertaken before the vehicle is used. The check can be in paper form or via the mobile phone app, or whether we do not require a walk-around check. I propose that we do require a walk-around check, and the check is done via the paper form or the app as worded under the amendments. If everyone's happy with that.
Sorry.
Second.
I'll second that.
Everyone agreed by affirmation?
Yeah. Okay.
Lovely, thank you.
I must admit, I'm not the exact wording for how that's going to be in the policy is slightly unclear to myself.
It's
so
in
is that,
this. It's in this.
On this bit, you mean?
yes, exactly. Just the rough is there, but can I just ask that that is clarified after the meeting and specified exactly how that's going to be written out. That can be done with delegated authority.
I was going to say, is everyone happy to delegate the wording, the amendment to the wording, as we have discussed, to be as per the DFT best practice guidance our authority requires?
And back to the chair for confirmation.
Yeah, and if you're happy for that to be delegated, to be brought back to me by the officers and for me to agree moving forward. Is everyone happy with that?
Yeah.
Okay.
Thank you.
Right. Thank you. Thank you for clarifying. Okay, and the next amendment we have is on the page 102 at paragraph 27D2. And that's again the referral to where information is received as part of the application process. It's the same as what's been discussed before. This is in relation to relevant convictions, that the applicant has the right of appeal to the licensing appeal panel or the magistrates court.
Can I just check? Sorry.
Councillor Brennan?
Does that tally appropriately with the previous paragraph that we talked about?
Yes, this will be as the chair agrees a final documentation, but yes, whatever we agree, if there's any revisions to that, it will be married here, but this is exactly the same as we just discussed before.
Yeah, because it's when the application is refused. It does say the applicant will have the right of appeal to the licence appeals panel. And I thought we'd said...
This is as part of the application process though, so when it was part of the applications process, I believe you had the option. Is that right, officer?
Yeah, so this is where we're looking at the operator. This is the operator application.
Yeah.
So obviously the conviction, again, we then automatically refuse. That is going to the magistrates, because it's an opposite decision.
No, that's
Whereas
not what... Sorry, that's not what this says. Oh, I see.
Yes.
The paragraph above. Sorry, you're
Yes.
quite right. The
And then-
paragraph above gives that detail.
That's right. And then any other information, wait, it's a bit of a grey area, so not black and white so far as a breach of our previous convictions policy. We have the option then, magistrates or to your licensing appeals panel.
And this just is the mirror of the reference to the operator.
The
Lovely.
driver.
So if everyone's happy with that amendment?
Okay, agreed.
Lovely. And then we have, under the same paragraph at G4, operators are also required to ensure all dispatch staff have been subject to a basic DBS check, but the checks do not need to be provided to the authority. So this, again, is the same as the previous comments. So again, if everyone's happy for it to mirror what we've discussed previously in that.
Agreed.
Lovely. Right, so the next amendment is... That's it. Right, I'm just going to check the amendments page just to make sure that we haven't missed.
The other appendices, I think, have not received amendments.
So on the responses to proposed amendments appendix A, there's the reference to NR3 becomes NR3s, NR3S, which was on page 8414D. So that hasn't been highlighted. 8414D. So yeah, under the National Registers of Refusals, Revocations and Suspensions, so it's just changing the reference there, but that's required. Anyway, so that's a legal requirement, so just for notification on that one. And then there's the competency test, which was amended to the maximum of 3 tests, which is on page 83 under the bullet points. 1, 2, 3, 4, 5, 6. So it's this. So 14A, page 83. Sorry, one moment. So the third bullet point down.
Fifth bullet point from me on your new application requirements, Chair.
Yeah, 5th bullet point in total, the third one on page 83, if you have the new one, where you've got the maximum of 3 tests may be taken before the application will be refused. So that's the inclusion of that requirement. Does anyone have any comments in relation to that one?
Just a grammatical
Councillor
one.
Bradman?
Thank you. Just a bit puzzled by the wording there. I agree with it, but evidence of completion and passing of the approved competency knowledge test course. So that's what's required. They have to provide that. And then a maximum of 3 tests may be taken before the application will be refused and a new application can be submitted? I thought the purpose of not... This is because in order to apply for a licence, they have to have these, as we referred to Councillor Hansraj, they have to have evidence of these other tests having been fulfilled satisfactorily. So they've got one application to be a licence holder, and they have to provide the competency and knowledge test course, and is it the maximum of 3 tests for the knowledge and competency course, or is it a maximum of 3 applications?
3 tests may be taken for the knowledge, for the competency test.
But then once they've done, suppose they did 3 tests and failed, do they have to itemise all 3 tests that they've taken and show that
No,
they've...
this is only the competency test subject is one. Competency stroke knowledge test. You can remove the word knowledge if you wish.
But what I'm saying is, do they have to, how would you know that they'd undertaken 2 tests and then passed when you're doing this application procedure?
Because we see every application that comes through is a form that we provide, so we can see the driver's passed or failed in that test.
Okay, so if they then tried to apply for a driver licence and they had but they'd actually failed through to... What I'm saying is the wording here doesn't make sense. It says a maximum of 3 tests may be taken before the application will be refused. But actually seems to me that's... If you've taken the competency test 3 times and failed, then you can't submit that information as evidence to your licence application, can you?
Sorry, Chair.
How does that work?
What currently happens is this knowledge test is one of the later stages of our process currently. So they've done the DBS check, all of this. Our officer has said, right, you can speak English, I can understand you. Here's the link to the competency test. That is what currently happens.
Yeah.
So we then look and say, right, Mr. X has done the test once, he's failed, twice he's failed, 3 times, and then we say your application is rejected.
Okay.
From there, it would not go any further, so he wouldn't get his medical done, etc., etc.
Okay.
So at that point, you have an application, 3 tests failed. What you're actually just clarifying by saying, and a new application can be submitted, is that a new application must then be submitted. So it can't come under that application, it has to come the next
Fresh
stage,
application,
has
that's
to come under a
correct.
fresh application.
Absolutely, that's right. So we reject the application because he's not met the fit and proper requirements. That application is then gone, so he has to wait 3 months before he submits a new application.
So do we need to just clarify the wording
So
on that? Say a
maybe
new sorry, Councillor Bradnam, I'm just speaking.
Must
Hang on.
be submitted.
That's what I was just about to say. So if you then say a new application would then need to be submitted or something similar to that, just to clarify that point.
We can of course, Chair, agree.
Yeah.
After this meeting, yes.
Councillor Hales?
Right, in that 3rd bullet, in the evidence of completion, passing, approved, competency, knowledge test, blah, 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 a maximum of 3 test attempts may be taken before the application will, maximum of 3 attempts will be taken before the application will be refused if, or something along the words of that, if you failed it.
Yeah.
Full stop. A new application can be submitted, but it won't be until 3 months have elapsed or whatever it happens to be. Something along those lines. Cut out half that sentence.
So just tidy up the wording just to make it clear.
Essentially, you can do 3 of them, but if you fail them, right, that process finishes and you can't reapply for 3 months.
Yeah.
And I think just the words that you have to use, it did get a bit wordy.
Yeah.
I reckon I blame Joe for that.
Officer Jackson, if you're happy to...
Absolutely fine, thank you, Chair, yes.
And if the committee are happy for that wording, once it's clarified, just to be checked with me and added to the policy, just to clarify that section. Are we happy with that?
Yeah.
Okay. Right, so I'll just go through. And there is the proposed change for trailers as well, which is in the policy at, it says page 92 in my notes, but I don't know if you can clarify that, Jackson, where that new there's a change for a new section in relation to trailers, where that would be inserted into the document.
Yeah, it will be into, I think I put on here 16. Let me just have a look for vehicle
16I.
requirements. Yes, it'll be a new, basically it's a new section within your policy. So we can agree where that is located if you're not happy with that. But as I say, the final version, you will have that, of course.
Okay, so just to propose that that would be at 16I, unless anyone has any objections to the new section to the policy in relation to trailers, which is identified in the proposed amendments. If everyone's seen those, does anyone have any comments in relation to that? Councillor Bradnam?
Yes, there was a certain amount of narrative in the driver's responses saying that the vehicle used to transport the passengers should also be the vehicle that is used to transport their luggage, and that they didn't feel it was appropriate to have a trailer in addition. And I had some sympathy with that because obviously you want to have your luggage with you. I just wondered, I don't recall looking at that at the workshop. I might have just forgotten, but I just wondered what members felt about that, whether they were comfortable with their luggage being possibly transported in a trailer on the back of a vehicle. I mean, I'm just thinking, it means that our officers would also need to be examining trailers as well as vehicles, wouldn't we? And I'm not sure we do that at present. And sometimes there might be a trailer on a vehicle and sometimes there might not. And whenever I've been on an airport transfer, I've expected to have my luggage in the vehicle with me. It's not always comfortable, but at least we know you've got all the luggage with us. I just wondered whether members had a rumination about that.
Councillor Hales?
Hire a bigger vehicle.
Sorry?
Hire a bigger vehicle. I've been
exactly,
abroad with
that's
lots of
my view. I
cases.
think you should
There's
just
4 of us. We can get in the car, but we ain't going to get everything in. We need a minibus.
Yes.
End of conversation. Costs you more, but your luggage goes with you. I don't think we should have trailers.
No, I don't think we should.
Councillor Wilson?
I agree. I think if we have trailers, then we have to go down the road of what signage there is on the trailers as well, or how it's attached, or whatever, to make it safe and visible.
Can, Officer Jackson, can I just ask what the reasoning was in introducing the new section?
Yeah, thank you, Chair. It's actually from Tasha, who used to work at West Suffolk District Council, and they had a specific policy because you've got, say, a lot of airport runs. If you've got a family of 5, 6 going on, say, a ski holiday, that's an awful big vehicle to have to use. But I say, we haven't had it in, we've never had it in the policy, so it's not a massive issue if not, but it's just to allow people, if they did wish to use trailers, that we have some guidance and regulations in here to say what they should comply with. So it's not, it's just something if you wish to have it in. If you don't, then it means somebody can have a trailer without any, because we're not saying you can or you can't. So we are then saying, with this, if you have a trailer, you've got to meet these requirements. But if you don't have a trailer, so we scrap it from the policy, it means someone can choose to have a trailer in there without any other restrictions whatsoever.
Concerned.
Councillor Bradnam, then Councillor Hales.
Sorry, what I'm concerned about, and I tend to agree with Councillor Wilson, and I do go skiing, and I have taken lots of equipment with me, but what I'm concerned about is that if we allow trailers, they must be licensed and labelled in exactly the same way as the vehicle, and I'm just a bit concerned about that. So I'm not sure I'm in favour of. I appreciate the wording would simply allow for, but I think we could end up with a whole lot of unregistered trailers that might not be up to standard. We'd have to be inspecting those as well, and I'm not sure I support that.
Yep, Officer Jackson,
Thank you, Chair. Just to confirm, it's not in the policy at the minute, which means a driver can choose to put a trailer on his vehicle currently. So we aren't regulating now. Out of our 1,800 vehicles, we could have one vehicle who's got a tow bar fitted and who wishes to use this. But what we're saying is, if you do have a trailer, you must do X, Y, and Z.
Okay.
We're not saying thou shalt, but I'm saying currently we haven't got anything in there to say yay or nay, councillor, to be honest with you.
Okay, and councillor Howe?
Yeah, thank you, Chairman. Chairman, I am in favour of trailers, but at the moment I think we're trying to make up a whole policy a bit ad hoc. So can I make a suggestion that the officers go away and write up a policy for trailers, and I'll explain why I'm for trailers. Is that because if people with disabilities go on holiday, very often they have to take an excess of other items that we don't, such as pads, a mobile hoist, even a second or third wheelchair, depending on the situation. So I am in favour of trailers, but I do think we should have a policy written up and then we can discuss it and take it from there. Thank you.
Councillor Sanford?
Thank you, Chair. Yeah, I'd agree with Councillor Howell's remarks. Having recently passed through Heathrow, there are large families who travel with a huge number of suitcases, and even upgrading to a minibus wouldn't get all their luggage in. But before we introduce this new policy, definitely we need the officers to come forward with guidance and requirements, please.
Officer Jackson, do you have any comments in relation to that?
No, quite frankly, this was lifted from a, say, neighbouring authority who had this section within their policy, and this is obviously what came to your good selves in the workshop in the spring of this year. But as I say, I have no objection if you wish this to be removed, and we can reconsider it when we look at other aspects at our next review, Chair.
Can I just get confirmation from the room that we would be happier for this to be reviewed when the policy is reviewed next time and we have a full proper briefing on it? Yeah, if we could do that, please. So at the moment that is not going to be included as a new section in 16. Okay, so we also discussed at the member workshop including a new change, a new paragraph that category A, B, N or S write-off vehicles will not be permitted. So this would be a new section that's inserted. Currently nothing restricts the licensing of insurance write-offs. There was some discussion about this, and you'll see the responses in the consultations. It's supported by 2 and opposed by 21. And there have been comments in relation to the fact that if it passes an MOT, is considered safe by the DVLA. Why does the licensing authority have the right to say that it's not a roadworthy vehicle? So does anyone have any comments on this? Agree to include it, or you agree to
include the new paragraph which excludes insurance write-offs?
Does everyone agree with that? I personally, I'm not sure, just to be confusing. Councillor Bradnam?
Whilst I think broadly speaking I do support the addition of this new paragraph, what I observe is that the decision to write off is a financial one, and it doesn't necessarily reflect the roadworthiness of the vehicle, because sometimes quite small things can happen that because of the vehicle it's happened to, insurance companies call it a write-off. However, I think broadly speaking what we're dealing with is vehicles that we expect to be at the highest level of roadworthiness to be carrying our passengers. So broadly speaking, I think we should include this paragraph. But what I'm mindful of is that some of our, when you think about private hire drivers, their budgeting decisions around the costs of a vehicle and how they pay for them are related to the length of time they're going to be, they can use them. And so they need to be mindful of this when they are making their choices about their vehicles. And of course, because of the mileage they do, they're more likely to be involved. Just because of the road mileage, they're more likely to be involved in an accident, even if it's, it's not caused by them, it might be caused by other people. But broadly speaking, I think I support this to go in.
Councillor Howell?
Thank you, Chairman. Chairman, unfortunately, we can't never tell if the vehicle has been pranged and just been written off, but only just, or has been written off quite severely because it's had a major accident. And therefore, I think we have got to include this catch-all. My colleague here has got far more experience of this being in one of the emergency services. But, you know, we have, as Councillor Bradman said, got to look after the public and the highest standards. So I would put this paragraph in.
Thank you. Councillor Hale?
Yeah, I totally agree with what Mark just said. We hold our licensees up to a very high standard, and I think the council approaches a very high standard continuously with public safety and what have you. One of the things that has opened my eyes was I was told when inquiring about a new car that the electric vehicle I was looking at would not have a jack, because the manufacturer does not recommend that Joe Public jack up their cars even for a puncture in case you warp or crush the battery compartment. So if a car has been any kind of certainly an EV type car, and there's lots of those around the city in our area, any of those have been in a particular shunt or anything, then that floor pan could be compromised. Still pass an MOT, but you don't want it catching light. So I personally don't think any cut and shut or anything like that is a good idea, and I would support the inclusion of that denial.
Thank you, Councillor. I, like Councillor Bradnam, I had my reservations, but I take on board and actually would say this would fall in the balance of including this. So I just wonder if anyone has any other comments. Councillor Wilson?
I have experience of one car being written off twice and still passing an MOT and still being insured. Not my car. But in this case, the car is quite elderly, and there is a tendency to think that if a car has been written off, it's because it has very low value and that it might be older than the standard that we would be expecting for private hire vehicles.
That's a good comment, yeah. Okay, so we have a decision to make on this one. So the decision is either to introduce the no write-off requirement, or in considering responses not to include the no write-off requirement, or an alternative agreement. Based on what we've discussed, I propose that we introduce the no write-off requirement to the policy, and if everyone can confirm. Second that one. Councillor Budden, second.
Agreed.
Agreed. Thank you very much. So that'll be included at an appropriate section if you're happy for me to confirm with the officers where that will go in with the policy.
Yeah.
Lovely, thank you. Just checking through just to make sure we have included the rest of it. So there is a requirement of a change to safety equipment. So I'm just going to clarify where this is. One moment.
It's at the bottom of page 63.
Thank you.
It's at the bottom of page 63.
So page 63 is where the requirements detailed. Can I just ask Officer Jackson, where would this be included in the final policy? Is the requirement to remove the requirement to carry the first aid kit? Where is this detailed?
Thank you, Chair. I'm just looking myself actually where we have it in here, because it will be within the vehicle standards, to be honest with you, as we'll discuss in any case, but that will be in section 20.
Section 20.
Apologies, it's just with a different numbering there. It's very confusing.
So that's starting at page 98.
Thank you. So the proposed change is to remove the requirement to carry a first aid kit and to remove the requirement to carry a fire extinguisher on the rationale that drivers are not medically trained and shouldn't be administering first aid, and the National Fire Chief Council recommends that local authorities that require fire extinguishers should ensure suitable and sensible training is received by the drivers. So So I just wondered, does anyone have any comments in relation to removing these two requirements? Councillor Sanford.
Thank you, Chair. Many vehicles actually come with a first aid kit as standard. Are we telling the drivers to actually remove them because they're not trained to use them? It's a bit vague.
Sorry, just to confirm, Chair, we're just saying it's not mandated. So if you wish to carry a first aid kit and a fire extinguisher, you can. But it's your choice, of course, because you may wish for personal reasons. You're travelling with a young child or family, you just want to have it as a safeguard. But if we mandate it as a local authority, things get a lot different.
So it's the removal of us requiring them to carry it. They obviously have the option to carry it. Does anyone have any further comments? Just Councillor Walters.
Sorry, not really. I do think that we should, they should carry fire extinguishers and first aid kits, just regardless. It's not going to do any harm if they do, so.
Yeah, they can do it. It's just whether we actually want to require them to do it, given the advice that we've been given that training should then be received by the drivers. Do we then have to mandate that if you carry one, you are required to carry one, and you now have to also do training, or how would that be? So is it? Councillor Hansraj.
So it would be good if they carried a fire extinguisher, but there's no point if they don't use it correctly.
Yes. Councillor Howe.
Thank you, Chairman. Chairman, so do I take it that if we were to mandate that a first aid kit would be required, we would then have to look at them doing some sort of first aid qualification? And then that would be I'm thinking aloud here, and then that would be part of the licensing requirement that they would have to. Starts getting a bit much at this particular point. I mean, I can understand the benefits of it, and I think it would be very good, but maybe not at this particular point.
Councillor Hales.
Yeah, I agree. And as to the fire extinguisher, as was said, they are used in a particular way, and you know, having done it for a living, it kind of does beg a belief. It's your own personal choice. I mean, if you don't want your car to go completely up in flames, and you can put it out, then fair dues. But the ultimate thing is get the passenger out, stand them on the corner, and call the fire brigade.
Councillor Bradnam.
I think the point is that this is currently in our current policy. They are required to carry a first aid kit and a fire extinguisher. This question is, are we going to remove that requirement so that they can, if they want to, carry a first aid kit and a fire extinguisher, but we are removing our requirement that they should carry one. We're not saying it's essential.
Can we not just say it's just optional? You know, it's up to you if you like to do it.
That would then be optional then.
I think the other point I wanted to make is that, as I recall, yes, quite apart from the fact that suppose there was an under bonnet fire, actually opening the bonnet to administer the fire extinguisher can cause a flare. So that's not a good idea. I was once witness to a friend of mine assisting somebody else in a fiberglass vehicle who did manage to put the fire out, astonishingly, but the vehicle was nevertheless obviously a write-off at the end of it. I think the problem is that the volume that you can carry in a small a fire extinguisher that's small enough to carry in your car is probably not big enough to put out a really major fire. And the other point is that for many electrical vehicles, I suspect the use of foam is not necessarily appropriate. So I think there's a concern always around, and Councillor Hales is absolutely right, the first thing should be to get everybody out of the car. But I think it's not unreasonable for us to remove this requirement. If people want to carry them, it's up to them, but I think it's reasonable to remove it.
Councillor Sanford.
Thank you. I was actually going to make the same point that Councillor Bradnam just did. We can't mandate fire extinguishers in electric vehicles. The first time they squirt light water foam on an electric vehicle, they'll probably get a fatal shock. So definitely need to remove that unless we're going to distinguish between EVs and fossil fuel cars, which is probably not within our remit.
Councillor Hales?
Okie dokie. Ready? Right. Having done this, totally agree. Pouring water onto a very high voltage battery may not be the best thing, but foam or dry powder, which are mostly car extinguishers anyway. So that would be perfectly okay. However, I still don't recommend it because it goes like the clappers. And I will like to say that this is only anecdotal evidence because when I was serving in the fire service, we didn't have electric cars. It's that far back. Only milk floats, and I never saw any of them catch light. But anyway, point to the. I think we could move on here, Chair, if I don't mind me suggesting is that, frankly, just make it optional. You do what you like. It's your car. It's your first aid kit. You're not obliged to offer a first aid to anybody anyway. I mean, because the fear of doing it wrong. And it's, I say, it's your property. If you want it burned, then burn. It's not a problem.
Thank you, Councillor Hales. So, Councillor Hales.
Regarding first aid kits, yeah, I appreciate that some training is needed, but if you're at the end of a phone to 111 or something, they can direct you. You say you've got this and this and that, and it would be good to have it. But then we need to put a caveat that that the driver isn't accepting responsibility for administering first aid.
So is it better in that case to remove our requirement to have it? Because at the moment it's about whether we are requiring drivers to have it. As Councillor Hales was saying, it's optional still.
May I respectfully, Chair, we have a lawyer sitting on the screen.
Oh, yeah.
I would say that the lawyer's aspect of this would be far better than ours.
Felicity, would you be able to comment on this? Is she up there? Hello.
Hello there, yes. Interestingly, I hadn't spotted this in my preparation, and I have just come across a statute which is talking about public service vehicles, and it says it's mandatory to carry a first aid kit, which would be diametrically opposed to the guidance here. So maybe it's something that Rachel and I can catch up on after this, because it's the first time I've come across a statute. There's two statutes actually. They are from the 1980s, so I'd like the opportunity just to research that a bit more.
Yeah, Councillor Bradnam.
Thank you.
I don't think, Rachel, sorry, I don't think there's any, sorry, Councillor Bradman, it's just because I've just come across it and I don't want to provide advice until I've read those statutes, and I don't really have time now to be able to properly evaluate them and cross-reference them with the guidance to be able to confidently advise you. I think it would take a bit longer.
Yes. And Felicity, I think the reason this was in the policy was because of that statute. I think that's why we put it in. I think we realised some years ago that we didn't have it in, and so we put it in. But I'm very happy that we review this and give you and Rachel Jackson time to work out what's appropriate. I think we've understood from the committee that we feel if we don't have to mandate it, we'd be happy for it to be taken out as a mandatory requirement. But I think we need to rely on your guidance with Rachel Jackson as to what we do. And maybe
my understanding is also in line with what Councillor Hale says, that there isn't any necessity to use a first aid kit. So perhaps it's worth looking at various statutes and putting those together, unless Rachel Jackson's able to come back on that to me now. I haven't raised it before. I do apologise for not spotting this prior to the hearing. It's quite a discrete point, isn't it? Because initially I just thought included, and then it could be relied upon if necessary, but looking at it, I don't know whether it's going to, this particular statute, Rachel, there's one from 1981 and one from 1986. They appear to be still live to me as far as I can see, unless you know anything that negates those.
Officer Jackson, do you have a comment?
Thanks, Felicity, and thanks, Chair. No, I don't. I should say, I think Felicity's right. We'll just have a catch-up afterwards, and then put the proposals to yourself, Chair, for the final approval. I think I've got the, if you wish, Chair, to agree to remove, subject to whatever Felicity's come back with, and then if we need to have a final say decision, I could always, with your, I was going to say blessing, with your approval, email the committee and confirm the outcome of the conversation with Felicity. I think that's probably the easiest option.
Can I just,
Councillor
sorry,
Bradman?
just one adjustment to that. I would suggest that the discussion is had as you describe, but can I just suggest this item is brought back to the next time we review the policy? Because currently we require it to be in, which complies with the statute that Felicity, the two statutes that Felicity has quoted to us. So can I suggest we leave it in for now, but review it in the light of legal advice the next time we review the policy, or bring it back at another time?
Yeah, I believe that's what Rachel was suggesting, was that it's reviewed. Then you have can I just finish, please? Then you have the option of either saying you agree to remove it if there is no legal requirement as identified by the Rachel and Felicity, or as Anna has suggested, we just review it at the next policy and it's all done in the background. I would personally propose that the first option happen. We agree to remove it unless there is a requirement that's identified by Felicity and Rachel that we have it. Is everyone happy with that one? Yeah. Okay. So we have about 4 or 5 points to carry on with. So I don't know. There's a request for a comfort break. So if we can just take 5 minutes break now, just to allow someone to have a comfort break, and I'll just clarify what we need to finish next. Okay. Thank you. Thank you for your patience and thank you for taking some, allowing us to have a break. Members, right, so I've gone through the reviews. We've got 6 points just to touch on before we finish. So there's an amendment regarding emissions. It's in your Appendix A at number 6, it's emissions. So it's to delete a section removing the reference to the Cambridge City Centre access for ultra low and zero emission licensed vehicles only, because the rationale is that this is now obsolete. So does anyone have any comments in relation to removal of this? No?
No.
Okay,
Agreed.
so we agree to remove that section. Sorry, Councillor Bradnam.
Thank you, Chair. It's currently obsolete because it was a proposal that related to the fact that Cambridge City and South Cambs District have in the past tried to keep our policies broadly aligned, because so many of our private hire drivers go across the boundary. And indeed, I noticed that Cambridge City have requested that this be reinstated, as the plan is still on track for 2028, as this will have no impact on the policy draft. This has been retained in the policy. So I'm not quite sure, do they mean their policy, or what is it they're saying here?
Officer Jackson, are you able to confirm just the response?
Yes, thank you, Chair. We're just checking the current policy, because there was 2 points of that. Was deleting 3.7A, which said, bear with me. We're getting there. The mouse is moving. It's the 3.7.
If you can just clarify where in the policy as well.
Oh, yeah, sorry, so 3.7A was now obsolete, sorry, in the apologies, this is the current policy we've got. 3.7A simply said, age of vehicle and emissions, until the 1st of December 2023, a new vehicle licence will be granted. So that is the obsolete part. So you agree to, yes, that's gone. And point C was, we said, we're removing the reference to the Cambridge District Council's, Cambridge City Council, the zero emission policy, but they're asking that, because we thought that had been renamed as something else. So it hasn't. So if we can please retain that part, but remove the obsolete A. So keep in C, as per City's comments, but delete 3.7A as it was in the existing policy, please, Chair.
Okay, just to clarify, it's to delete section A but retain section E, which is contrary to what... C, sorry, which is contrary to what's in the notes, but if I can have any comments or just confirmation that we're happy for that. Councillor Hales?
Yeah, I'll go with that, second that.
Yeah, okay, so we will delete section A and keep section C in that reference. Okay, so if we can go to this one, thank you. It's the accessibility paragraph. Just going to check it where in the policy it is. It's at page 96 under 20F, accessibility. Is that the one, Rachel? Can you just confirm?
It's a inclusive service plan.
Is that the right section I'm referring to?
Yes,
yeah. So this is just to rename from accessibility to rename it as the inclusive service plan. At the moment, there is background work and consultation going on in relation to the contents of this. So the proposal is at the moment just to rename the policy, leave the remainder of it as it is, and then when we do a review of the policy as a whole, we will take into account any of those consultations and any new guidance from there. Can I confirm if you're happy with that? Seconder. Yeah. Okay.
The only...
Councillor Bradnam?
The only observation I make is that accessibility clearly relates to providing transport that's accessible for everyone. Whereas I have to say, for a long time, I sat there thinking inclusive service plan related to a service plan for the vehicles. In other words, maintenance. So I'm just slightly, and I think if we can call it something that refers to the fact that it's point is inclusive can mean lots of things. In this case, it means inclusive for all abilities. So I just think it's.
Can I make a proposal that we change it to inclusive service plan for accessibility? So then it's clarifying that we need the guidance requires local authorities to develop inclusive service plans.
Yes.
So we've included that aspect of the requirement,
So
but it also makes it clear.
Yes.
So this would be to rename it inclusive service plans for accessibility.
Yes, agreed.
If you're happy. Okay. Thank you very much. And then we have this is in relation to lifts. So I'm just going to find the section in the policy. Paragraph 20F is the note I have. So it's under accessibility again. Paragraph 6. So it's F6. And this is in relation to operators providing valid lifting operations, lifting equipment regulation certificates of compliance. So it's to be reworded so that it says all vehicles fitted with a tail lift for wheelchairs must meet all requirements. Sorry.
Yes, exactly.
We're on
3.16.
page 96. Page 96 in the policy. Sorry.
Yeah.
Paragraph 20F6 at the bottom.
Okay. Right.
Are we all? Yep. So there is.
And this simply reflects that the regulations around.
That, Councillor. Thank you. So this is just going to be amended in order to future-proof it, so that it ensures it meets the future requirements moving forward for their health and safety executive. So the proposal is to just remove the requirement to provide a valid certificate of compliance, just to remove that section. So it will now read, all vehicles fitted with a tail lift for wheelchairs must meet all requirements of the HSE lifting operations, lifting equipment regulations, the LOLA regulations. Are we happy? Yeah. Does anyone have any comments?
Agreed.
Agreed? Lovely. Thank you very much. Then we have executive exemptions. This one requires a member's decision. So this one is at paragraph 21. No? That doesn't seem to be here, so let me just double check it. So it's executive, 23. So the private hire executive vehicles, it starts at page 97, but the relevant section is on page 98 at 5. So it's 23A5. Is everyone,
page 98.
Everyone know, got that? So this is in relation to, previously we've listed certain sections of vehicles that we would class as luxurious enough to be executive ones. So it would be changing and removing this V. So the bits that would be removed is from the beginning of the paragraph to the end of Bentley Saloon. So that includes all of the bullet points. In place of that, there would be the revision that vehicles considered for exemption must be at least category E or F EU classification of vehicle types, considered to be luxury standards such as BMW 7 Series, Mercedes S-Class, people carrier type of vehicles must be of the highest specification and in showroom condition. And then we would maintain the last sentence, the highest specification executive type cars from other manufacturers may also be considered. So it just takes out some of those examples in there, if you're happy with that.
Agreed.
Lovely. So this one being a decision one, it's a member's decision that considering the member's decision states, considering there are ongoing discussions to agree to retain the policy as present, but to revise paragraph, as I've just listed, 23A5, yeah, 5, relating to people type carrier vehicles, or B, to have an alternative agreement. So I'm asking that we agree to retain the policy, but with the revised paragraph as we've discussed. Agreed?
Agreed.
That's a member decision, thank you. we've got the last one. We have, regarding operators, suitability of premises at home-based operators, which is at 27B, private hire operators, suitability and eligibility, on page 101 of the new pack that we were given. So there was the rationale was there was a member's complaint that residents impacted business operations and limited parking by having excessive numbers of vehicles in, at there. So the proposed change is that a number of vehicles may be operated from a home-based operator, but be restricted to 2 vehicles unless off-road parking is provided, and existing operators will be permitted to renew licences with a number higher than 2.
So is this an additional paragraph or a replacement?
It's a change. I'm just checking. Rachel, can you just clarify which paragraph it's changing, or if it's adding in
Thank
a new
you,
paragraph?
Chair, of course, yeah. This will be, if it is agreed, obviously subject to, obviously we have some very strong representations against this proposal, including one from the Licensed Private Hire Car Association, as you'll see in the appendices, Appendix C. But this will be a new part in 27B, suitability and eligibility, because it's currently not restricted. It's all subject to, if planning, you've got an application, planning approve your application, or just say no objection, we issue the operator licence as applied for. We don't currently restrict the number of vehicles that may be operated from a home address, Chair. So it'll be a brand new inclusion.
Thank you. So that would be a new paragraph 5 at that section. Councillor Bradnam?
Thank you. So this would be 27B, new paragraph 5, wouldn't it? And what it would say is that the number of vehicles that may be operated from a home-based operator may have to be restricted to 2 vehicles unless car parking off-road is provided. Existing operators will be permitted to renew licences with a number higher than 2. I have had some experience of this in my village, which has caused quite a lot of concern. So if we, obviously there's been some objection to this being included. So if we did not include it and we left it as it is, if residents had complaints about the number of vehicles being operated by one operator from what was effectively a residential premises, how would that be addressed?
Thank you, Chair. We could actually look at that. Each case would be, I think we're about 150, 200 operators now. We've never had an issue before. I do recall it came, I think, Councillor Waters, it was initial concern from Councillor Waters and a local resident. But ultimately, we'd liaise with our planning officers, see what their concerns are. Does the building require a special permission to operate from the business, from the home address? If it's causing an issue, then we would actually speak to the operator, put a condition on the licence that would restrict the number of vehicles that may be operated at any one time from that home address. I feel, considering the responses we've had, and considering I do feel that this will be strongly contested as a policy decision if you actually should implement it. Not that this will sway your decision, but just for your information, councillors, I do feel this part would be challenged by way of judicial review if it was imposed as the initial workshop decision. I think you should be considering each application, as we do, on its own merits, following the feedback I've received and from the trade associations.
Councillor Waters, did you want to say something? Of course, yes. So it is. The proposed change is the number of vehicles that may be operated from a home-based operator may have to be restricted to 2 vehicles, brackets, unless car parking off-road is provided, close brackets. Existing operators will be permitted to renew licences with a number higher than 2. So there's obviously a discrepancy there. Councillor Waters, sorry, did you want to say something?
Thank you, Chair. Yes, as you know, I brought this up previously, but in my village, it has caused quite a lot of concern with local neighbours and they are worried about complaining. When I did go round and ask them, they don't want to be named. They don't want this to, because they worry about anything that may come back to them. I think that a taxi company going into a village semi-detached house and then bringing in lots of vehicles is not practical for residents and residents living nearby. It's quite upsetting for them, and particularly in my ones that I reference is an elderly lady of 90 odd living next door and her driveway being blocked, and then next door to that is somebody who's has carers come in, and again the driveway being blocked. So they just don't want to complain though. So yes, I think it would be a good idea personally.
Councillor Wilson?
I've got 2 sets of casework at the moment which relate to people being impacted by other neighbours parking too many cars around their driveways and streets. And there's one in particular where they're complaining that the amount of parking, emergency vehicles wouldn't be able to get through. So this does need looking at. And I was wondering whether the wording may have to be restricted, whether that leaves some flexibility for the officers to make a different judgment.
Councillor Hansrush?
I think you might know what I'm going to say. Parking is an issue, and it affects the elderly, the disabled, and people going to work, etc. I won't itemize everything I've written. I have a neighbor who has 2 taxis, runs some executive car. They're always out there washing, polishing, etc. It's an imposition on other people if they use their driveways, their car parks, obstructive. And I think it is reasonable that if somebody wants to run a business from home, they have to sort out the parking spaces within their premises.
Thank you. Rachel, can I just ask a question? What you were saying about ways of dealing with this issue, when a licence is granted, similar to what Councillor Waters has said, is there an assessment of the ability of the property to house cars? Is there another way of being able to restrict the licence on the number of cars so that it's not retrospective, it's actually more at the beginning?
Absolutely, thank you, Chair. I think as well it's taken that pragmatic approach as well, which is what this council has always been about. I just want to remind you that we already have it in our policy as well about suitability and eligibility. The business address, physical or remote, must be located within South Cambridgeshire District. When considering an application for a new operator's licence, consideration will be given to the location, the vicinity, facilities and parking arrangements. So we've already got that in. Just to allay your concerns, and obviously thank you, Chair, our enforcement officer currently goes and visits all new applications that come in. So he'll look to check whether they're aware of the operator conditions, etc., and also the location as well. I mean, typically now we have these virtual offices at Regis, for example. But if we are getting in these, then obviously the enforcement officer will go and say, actually, we'll license this, but we'll have to give you a condition on there that restricts the number of vehicles you may operate at any one time. They do have to, when they apply as well, they do have to state on their application how many vehicles they will operate as well. So, for example, if we had 1A the Crescent and he's saying 55 vehicles, then obviously alarm bells would sound with that application in any case. But before we actually license them, they are checked as well by our officers.
You are visiting to make sure the premises do facilitate the parking for this. Councillor Hansrush, you wanted to say something?
So it concerns me that when there's a breach of this, obviously there are people like the elderly who are unable to complain for their own reasons, and all these obstructions will be taking place. and the council won't be notified of these breaches.
I was going to ask a question, but Councillor Bradnam, you wanted to say something?
I think it would be helpful if Councillor Hansrage's question was answered first,
Yeah.
and I'll come back.
My question related to Councillor Hanraj is, how are complaints dealt with? So if you do get complaints, how are they dealt with? And is there a way of addressing the concerns of Councillor Waters that people don't want to make a complaint because it's obviously their neighbours?
I mean, there's a couple of ways to deal with it. A lot of times we'll have a complaint about X person. If it's your neighbour, it's quite obvious. We've got a complaint about parking. People will know it's going to be one of the neighbours who's objected or complained. But there's sensitive and subtle ways we can deal with an issue. And obviously just going to talk to the individual first of all. We've obviously got our enforcement concord, our enforcement protocols, which say how we deal with approaches and breaches. If we felt there was a planning breach, then obviously we refer to our planning officers to actually say, look, it looks like he's operating 15 vehicles from his home address. It's probably not incidental now to his main business as his business is bigger than the residential aspect of that. So speak to our planning officers. But if there is another issue, we just go and talk. We're not heavy-handed. We'll go and have a conversation or a call with the operator and say, we've got this issue. What can you deal with this? What is the problem? You've been blocking the road. We have a lot of complaints about someone's parked up in my blocked my driveway when they've gone on holiday for 2 weeks. We have that a lot. We can report that to the police for obstruction. We can only do so much for obstruction, but it's obviously the police, it's their responsibility. But if we know we've got a problem emanating from an existing operator, then that is what we do as part of when we get the complaints in, we investigate every single complaint we get. So we go and talk to the operator. We wouldn't say, Mrs. Smith next door has been complaining about you. We do it in a very sensitive way that wouldn't allude to having a direct complaint from a member of the public, if that makes sense.
Where we have the wording of may, which has been referred to, so at the moment the proposed change would be the number of vehicles may be restricted, but isn't that already the case? That it may
True,
be
actually,
restricted?
yes.
If you're saying you don't have parking, you may restrict their licence.
Yes.
So it's already
It's embodied in the policy, you're quite right actually, yes. So it's a question, do we need to change it? If it's already, we have the ability within our existing policy, without stipulating and without causing a lot of alarm to existing and new operators, because it's already empowered here. As officers, we've already got it in your policy to say, actually, we can do whatever we want within reason, because it's already in here. We can restrict, we do consider the location, the vicinity, what facilities you've got, and the parking arrangements. So it's maybe a question of, we've already got that power in, page 101, 27B, italic I, number 1 rather, is we already have that. We already have those controls available.
Councillor Bradnam and Councillor Houser. Councillor Bradnam.
So a couple of things. What is interesting is the observation that we've been advised that if it became apparent that the number of cars at a residential premises had become problematic and it was raised with the authority, you might take it up with planning and there might need to be a change of use. Now, that implies that there isn't automatically a reconsideration of the use of the premises, which is a residential property. That doesn't happen automatically because I suppose any operator might have 2 cars parked on his premises, and indeed any member of the public might have 2 cars parked on their premises. I think the concern is that we are sufficiently vigilant when somebody's making an application to be an operator to ensure that their premises is suitable for that business, because basically it's a residential property.
Yes.
And often these are on actually quite small and cramped estates. So I think I would like to see, be reassured that our officers will take regard to that quite vigilantly, because, as I say, you might only have received 1 complaint, but I actually did raise an issue of a property in my village, because, again, it was on quite a small, constrained road. They had a big driveway, but they had 4 cars on the drive and a further 4 on the road, and it was quite problematic. The second thing I just wanted to raise, so that's a question about vigilance when people make an application to be an operator. And the point is that this is an operator premises. Now, this could just be a person on a telephone. They might have vehicles locally, but most of their drivers might be at their own home and working from there. And indeed, this is the point in this third bullet. I don't concur with the bit about new operators and people working from home. But the point is, most of the operators would just have a telephone operation and they would dispatch driver A, who is actually currently at their own home, and would work out from there. So it's not so often that you get an operator in a residential premises where people were coming to it to pick up the car, and then that's more applicable to something like a bigger operator. So again, it comes back to my mind that when we are registering operator premises, or indeed operator driver premises, or just a driver premises, we need to make sure that, for example, drivers aren't, I mean, it could be driver A plus their 3 brothers and sisters who are also acting as drivers. You know, we just need to make sure that the premises that people are working from is suitable for the purpose that they want to use it for. So it's sort of like beefing up the vigilance when people apply, I think, is kind of, is there some way we can do that?
Well, I say each, sorry,
No,
thank you. Each applicant is visited. I say recently, from what I've known, there's not been any new, I think it might be one home-based operator, but typically, so they are Regis, you know, virtual offices space and this kind of thing. So it's not really been seen to be an issue. But I think you're absolutely right to just be vigilant and keep an eye on this, and obviously keep on doing what we're doing, but it is the individual operator is checked in person, you know, so, and they have a visit with at least one officer. If it's a new establishment, we tend to have 2 officers going as well, to be honest with you, just to check on, you know, the location, and looking at the broader side of it, not just, is he going to be able to meet the conditions, etc., but looking at, you say, is in line with our policy, is it suitable, etc.
Can I just come back briefly on that? So if when you visit, obviously they will have told all their drivers to park elsewhere, if there are a number of it, or they will have parked all their vehicles elsewhere. So if then somebody objected to a number of vehicles being parked near a residential premises that were causing a problem, that could be referred to you, and indeed people who feel nervous of, like Councillor Waters said, who feel nervous of reporting it directly to licensing, they could alert their local councillor, and we could take it up. You know, the councillor could take it up on their behalf, and that would all be dealt with anonymously, I think. So I think there are ways around it, but I would just like to make sure we make sure that the premises that either operators or indeed operator drivers are working from would be helpful.
Thank you. Councillor Hales?
Thank you, Chair. I think our ultimate goal is to make sure that whatever we licence doesn't seem to upset the general population. Right, so I can give you an example. Back in my ward, we had an operator who had a maintenance garage as well, and they worked out that as the operation for the call dispatch as well. They had off-road parking for 9 vehicles, if I recall, and they still parked on the road, half a dozen on the road. The drivers would turn up willy-nilly at all sorts of times and day and night. And so therefore there is that angst, if you like, that starts to grow within local communities. I can hear what Councillor Waters and others have been saying, and they're absolutely right. And Danny, and something that Councillor Braddon just said just now, about if you don't feel able to go through the process of reporting yourself, then you do have an elected individual sitting in your ward, you could go through them. With regards to the example I gave earlier, there was conflict, I think, polite conflict between planning and and licensing, because licensing has its set of rules and regulations and environmental. And then when planning comes and they said, well, their planning says they can park on their off-road parking, and they've got those parking bays there. But we don't have jurisdiction over the highway because these are vehicles that are licensed and park anywhere they like on the highway. There's no parking restriction. And so therefore you then fall into a different category. So there is bumps in the road, yeah, rather than potholes for once. There's bumps in the road that cause issues for everybody, I think. It was mentioned earlier that it would be preferable perhaps that our officer team are very active, if you like, and very on it. I suppose there's been a couple of examples here today that have been mentioned, one in Councillor Walters' area and one in Councillor Harage's area, where you've got prime examples of operators or owners of cabs working on their cars, cleaning their cars, doing whatever they're doing. No different to anybody else who owns a car. Big difference is that's a business, and they're doing it to the detriment of those around them. So, if you like, the lack of respect is starting to materialise. So, how that is dealt with, I don't know, but it's just a thought. I mean, we are talking about a policy which has draconian measures in it, and it's requirements for this and requirements for that. And frankly, if you're running a business, go and find somewhere to run it out of, not in your house where you've got dozens of cars turning up. Thanks.
Councillor Hansrush, you wanted to make a further comment?
So my questions have actually been asked already.
Okay, lovely. So we have to make a decision on this one. The question is whether we feel that the appropriate route is to include this change, or whether we feel the appropriate route is to use the existing policy and ask that officers be, especially with residential premises, be more mindful to do that. Councillor Howell?
Chairman, I believe that we should stick to the current policy and leave the officers and others to liaise and find out if that is the best solution. It might be good for some places, the house might be out of the way and not cause an issue, and the other ones then might be in a central conurbation and need more careful thought. So I think it should be left to the officers.
Okay. So that would be supporting that the restriction is not included. This new restriction is not included. Do I second her? Councillor Howes and Councillor Brennan. So just by affirmation, do we agree that this new is not included, this new paragraph?
Agreed.
Sorry, Councillor
I was
Waters.
just going to say, could you read it?
Of course, yeah.
Please.
Absolutely. So the proposed change was the number of vehicles that may be operated from a home-based operator may have to be restricted to 2 vehicles unless car parking off-road is provided. Existing operators will be permitted to renew licences with a number higher than 2. The decision is to implement the restrictions on home-based operators, i.e. to include that paragraph, or considering the response is not to include a restriction within the policy. Officer Jackson has said that there is information and a basis in this policy for the may to be included in other aspects of it. Is there a specific section at all, Officer Jackson, or is it just within the policy as a whole? Could you just clarify that?
Could Ms Jackson just clarify what it says currently? It says nothing regarding numbers of operators.
So it just, it's within the policy under its own licensing
so
restrictions
you
that you would do when you consider an application.
Absolutely, Chair. So yeah, just to confirm, we have it quite clear on the suitability and eligibility in the current policy. We will take into account location, vicinity, facilities, etc. So nothing will change. It would have been the proposal. Had you agreed to this restriction of 2, that would probably have been suitability point 2 on here to say numbers restricted to 2, for example.
So the decision proposed is that we do not include this new paragraph. Councillor Howes?
Just as quickly, if I might make a request through you, it's been mentioned in 2 wards, to my knowledge, 3 if you like, if you include mine. And they were at the opposite ends of South Cambs. They're like the 4 points of the compass. I just wonder whether it would be worthwhile, prudent, and now we're meeting here and we've talked about this, that whether Rachel Rachel will do for the moment, Jackson, sorry, Miss Jackson, would be kind enough to ping an email out as an all-points bulletin to our colleagues, councillor colleagues, just to say, you know, put it out in your reports, put it through parish councils. If you do have a grief with this particular area of our world, then have a word with your councillors, and then they'll bring it back through the system, and you don't have to be necessarily identified, and that would be great. And then do it that way. You know, just be a bit. Let's work the officers harder. You know.
Yeah. So just to clarify, we are agreeing not to include this paragraph by affirmation, and we're also requesting that the officers put out a call to the councillors so they can check if there's any issues and deal with any complaints or issues through there. Yes, Councillor Bradney.
And the only other thing would be to clarify to the licensing department that we would like them to look very carefully at the premises when an operator or a driver operator or indeed a driver licence application comes in, to make sure that the location where cars may be parked is going to be adequate for the operation that's envisaged.
Yep, thank you. Just to confirm, we have the operator checks. Thank you.
Lovely. Okay, so just to finalise these Hackney Carriage and private hire policy revisions. So the recommendations were that the licensing committee consider the proposed amendments, which we have just gone through, and consider the feedback.
Sorry, Chair, just one point very quickly. We did cover it, but we've not actually got to agreement. Was point 8 about the MOT. It was just something in the guidance. I know we've discussed it, but you haven't actually got your agreement. Thank you.
Thank you for the reminder.
Which is on page 92, Chair.
So we discussed the requirements for MOTs for vehicles regardless of age, but we, just to clarify, it's at page 92. Paragraph 17, just to comply with the guidance that an MOT test and certificate of compliance no longer than 1 month before the application by an SCDC approved garage is required for all vehicles regardless of age. So it no longer has the period of a new vehicle without having it.
Agreed.
Agreed. Yeah. Okay. So, yeah. Yes, Councillor Waters.
Could I just make a suggestion that some of the things that we've been discussing go in the South Cambs magazine, and then that is information widely spread. I don't know if you put pertinent things in, or what if you could talk to me, Rachel, and just say, and we could put some things in the South Cambs magazine.
Yep, we can have a look at that. I think if you just have a look at that and feedback to us as by email.
Of course, Chair. Yeah, I mean every quarter we get a pitch. Unfortunately, the timing was awful because I think the deadline was last week for the whatever month we're in for the new magazine. Apologies, but we'll certainly put it in for the next one because John always gets an email to say we need some suggestions. So any input like this we'll have. I've already been in contact with our media officer because she was interested in a story about the street trading, and I said, how about a release on the taxi policy as well? So she may well come back with that. But any opportunity we have, it's just because my bosses tell me I must do it as well, is to be promoting more of what we're doing and what you as a council have done as well.
Absolutely, I think that's brilliant. And also, I'm on the South Cambs magazine when we put them stuff in, so I can address that for now.
So I shouldn't have any problems then, councillor, should I? Really, I should get my pitch through. Okay, is what you're saying. Thank you.
So, just going back to agenda item 7, I just want to confirm the recommendations. So, consider the amendments which we've done, consider the feedback from the consultation and the additions and revisions to the policy. There were 15 revisions, 5 of which required members' decision, which we've gone through. There is also the licensing committee consider revisions to the penalty point scheme, which were agreed in principle at the members' workshop and attached to annexes within this policy. Rachel Jackson, if you could confirm that one.
Thank you. Yes, it's not controversial. It's just to try and simplify the processes, and ultimately, rather than defining penalty points X, Y, and Z, it will be in certain circumstances, as per the guidance there. The information in the agenda, that decisions of certain nature would go to myself or to Mr. Hall to determine the best course of action, be that revocation, 6 points, etc., etc. So, in a nutshell, that is the proposals really in there, and changing a few from 3 points to 6 points to just regularise it. But it was exactly as per your the workshop and as per the appendices, Chair. Thank
Which
you.
is at page 141 in the pack under Town and Police Clauses Act 1847. There's a list of offences and the points, if anyone wants to have a look. So, are we do we agree that those revisions agreed in principle at the members' workshop and attached at the annexes are to be agreed moving forward?
Agreed.
Agreed? Yep. Okay, so the other thing we had to consider was the requirement for safeguard trading for new applicants and the minor revisions within the policy, which was the requirement for the classroom information. So now the committee may agree one of the following options: to recommend that the lead cabinet member for environmental services and licensing approves the policy revisions, subject to the licensing chair approving the final draft, or that the lead member rejects the policy revisions. So I propose that we recommend that the lead cabinet member approves the policy revisions, subject to the approval of any minor revisions that we've had, and I would, as a second point, ask that you delegate that to myself and the lead cabinet member. So if I can have confirmation for that.
I'll second that.
Second and agreed. Thank you very much. So thank you very much for going all through that. I believe. Oh, Tilly, sorry, we've not.
Can I just say, because I just want to say, because you're clearly talking about me now, so yeah, I'm absolutely fine with that. Thank you, Annika.
Lovely, thank you for confirming that. So I believe now that we have covered everything, I'm just going to double check, just to make sure. Agenda gone. I haven't got the agenda. Where's the agenda gone? I have it in half palm. Let's look to the side. Have you got the agenda there at all?
We've done everything.
Yep. So we've done with that, and thank you for your patience going through all of this, and thank you to those who attended online. Thank you very much. That's the end of the meeting.